That's it. Ready. Go. Oh, ready? All right, I want to call the Ohio Elections Commission meeting of September the 23rd to 2021 to order. Use the roll call, please, Mr. Morris.
Yeah.
Ms. Collins. Mr. Bronner. Here. Mr. Norman. Here. Ms. Cunningham.
Yeah.
Vice Chair Beatty. Here. Chairman Price. Here. All present, Mr. Chair. Thank you very much. Mr. Ricker. Yes. Matter would be to approve the minutes of September the 9th, 2021. All should have received a copy. Any revisions or changes to the minutes? If not, I'll entertain a motion that we approve the regular meeting minutes of September 9th, 2021. Move to approve. Motion, we have a second. Second. For discussion, all in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign, motion carried. I'm still inclined to want to raise my right.
Oh.
I thought myself. All right, the next matter is case 2020G-019. I'm going to interject initially to request that the commission call up case number 2021S-055. Paul Nick Hudson, it's under the good cause items. Item number 55. With all the numbers we're running in the sequence today. The reason for doing so is counsel for the respondent in that case is present this morning. Ben Wallace, who is with the law firm McTighe and Colombo, is here on behalf of Mr. Hudson. As I indicated, my recommendation is the commission find a violation, but for good cause not impose a fine or refer the matter for the prosecution. The responses that were, the report was filed, but it was late. The responses that were submitted on behalf of both the initial treasurer and the indicated that there were various illnesses that they experienced in a period of time. The second treasurer used an email format for submitting reports to the secretary's office, thinking that was proper, and only later discovered that it was not. And so primarily based on the reflection that, you know, Council Cohen, would you please introduce yourself for the record?
My name is Jim Wallace, counsel for the Kentucky State Hudson Employee Husband. I don't have anything to add beyond what Mr. Victor said, but I do support a recommendation of violations, but I'm going to answer your questions.
Anyone have questions, council? Otherwise, we have, entertain a motion that we follow the executive director's recommendation, find the violation, but for good cause, trying to build the fine and not to breach the prosecution. So moved. Motion. And a second by Mr. Forrest. Stefan, all in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign, motion carried. Thank you very much.
Thank you.
Thank you very much. That is the only case I would recommend taking out of order. Okay. Because anybody else that's here, is here on, the next item. Okay. Which I'm sure you will quickly address and move on, Mr. Chair. Very good. Thank you, Mr. Ricker. Case 2020G-019, Hicks versus Freeman et al. I have
recuse myself in past and must continue to do so because of the conflict. And then transfer the gavel over to the vice chair. I'd like that record reflect that I recuse myself and I left the,
If there's anything to write there, how would
Well, I have, for your benefit on the agenda this morning, I put what I see as the motions to consider for everybody there. Mr. Bry's motion to dismiss, if completed in proper contact. Mr. Bry's motion to dismiss for lack of personal knowledge or limited. So, then the motion to quash for Freeman, the motion to quash for the Jay Henson. The motion to quash for Dean Schmidt. So that's the order in which I put them. I think that's what the commission should consider today. And you see listed on there my various recommendations as it relates to how they should be, whether they have any other comments that the commission may have.
Okay, let's proceed with, one. Great motion to dismiss the.
Do you want to limit presentation, because I think everybody should have had all the written materials certainly to them at this point.
I have a question about what motion for be considered involvement is not being clear on what motion to feedback. I made a summary of all the motions that I'm aware of in this case, and I don't agree with them not being considered or understanding why they are or not being considered. Is it okay if I hand out a list of the motions that are actually in the case?
I think Mr. Ricker just indicated which motions are being considered.
Well, I object to that certain motions are not being considered, because I don't think they're acting on prior meeting and anything to do with whether I'm allowed to cross-examine Alan Freeman on his sworn statement, for example, or whether, so I, the complaint in this case, feel like I'm being put at a significant disadvantage both on discovery and not even on potential help, because motions have not been heard, and they were not considered or decided in the last meeting.
I appreciate your objection, but if we don't have the materials placed before us to prepare for a hearing, then I don't think we as a commission are prepared to be able to make a ruling upon them. We have certain motions that were placed before us. You don't know to prepare those materials, but if you're asking us to rule on motions that we've not specifically prepared for today, I don't think that's fair to the commission.
I appreciate that. I don't think it's fair to me, but I don't know, for example, whether I'll be able to sworn affidavit. I don't know whether I have to take the same thing with that or not. Because all of those decided last meeting was that filing an affidavit didn't preclude you from, in a future hearing, exact words of the motion, being able to sort of your right to against self-determination. So I just want to be on the record that I'm at a significant disadvantage. And this is some of the issue that's driven the communications, is that I don't even get feedback on what motion was being considered in a meeting. That's unjust to me as a complainant.
I would request that you follow the commission and not be a part of the interject on everything.
I'm just going forward with the agenda. Put your objection on the record and things like that. So let's start with the motion to make this, your motion.
This, I don't think you had the ability, I don't think you were here last time, but what we did was a limited discussion as it related to each of the motions. But I think we had 10 minutes last time, but we've got 5 motions. I would say no more than 5. My recommendation would be no more than 5 minutes as the motion, so we're not here all day. I know we've all reviewed the materials. Any discussion on the commission members?
Start with that. If you want to come on.
So be it.
Mr. Chairman, members of the commission, I'm John Bryant here on behalf of respondents, Tom Freeman, and thinking. There are 2 motions to dismiss that we have filed. First one, which I'm going to explicitly argue now, is the motion to dismiss due to complainants improper contact with commissioners. It's Mr. Hicks has repeatedly contacted members of the commission in email, arguing his position, arguing the merits of the case, expressing his dissatisfaction with the process, and disparages his counsel and counsel's client, as well as from time to time members of the commission and the commission statement. We haven't included all of the 5 of them, which were sent to every member of the commission prior to July 12, when Mr. Rickard, stop doing discussions with commission of the merits of the case, going deep into that, and disparaging comments and so forth, that cause people to have to please themselves and affect things with about the money. And after that, Mr. Hicks says, "You're wrong. I'm not discussing anything. It's a need." I can keep doing it, and I'm going. August 16 and 26, he then sent emails of the same tenor and tone, arguing the case of disparaging counsel and counsel client to all members of the commission. And although it's not an exhibit, it's as recently as this past Tuesday, he sent an email to every member of the commission, once again, arguing the merits of the case, arguing the merits of the motion, disparaging counsel, disparaging respondents in matters that are inappropriate. Respondents have a right, a constitutional right to a fair hearing. And the Ohio Elections Commission rules require that kind of fair hearing. Members of the commission, according to the statute, shall not discuss the complaint before the commission or panel of the commission with parties to the complaint. I'm not calling the commission. You can ask for the email they came to. But the reality is that when you communicate through email, that is a discussion. You've all read written briefs, as discussed below, as discussed above. That's a discussion. And the rules of the commission say all papers must be filed with the commission's say, not directly sending papers to the commission. The rules of the commission say that pleadings and motions shall conform to the Ohio civil rules, not directly sending a pleading, I suppose, in the form of an email directly to the commission. So it's not even in the form that makes a motion or requires us to respond to anything. And it says all parties shall observe the usual decorum as would be expected in the court. Nobody in the courtroom is going to be, at least if they're a lawyer, and want to keep their license. And you send emails directly to the jury, because you're finding that, or the judge, because you make rules on it. That is not the usual decorum. And it's not like this is a surprise. Not only did Mr. Rickard tell him in writing to stop doing it on July 12th, and he kept doing it. The commission's website has pretty clearly set forth how you do it and how you don't do it. His emails are also improper because they were ex parte. Now, ex parte isn't limited to emails that he didn't copy on. He copied on. But there are some case law that say that can still be ex parte, particularly whereas here, I could not respond to those emails without violating my duties as a lawyer, without violating the rules of the commission, but also without violating my duties as a lawyer. So, yeah, I know we had this email communication. I can't say no, this is right or that is wrong, as I could in real time if we had a conference, like we're having here with the commission, where we can go back and forth and express our views. They're also inappropriate because the disparaging opposing counsel are not based on governance, is highly improper. We believe that Hicks' repeated unlawful communications with the commissioners would make any hearing unfair, and for that reason, the complaint should be dismissed. He did it on his own. He did it when he was told not to. And you can't unring the bell. If you receive this argument, I understand, I don't blame any of the commission, but the reality is that this process has been so tainted by the misconduct of the complaint that it is impossible to have the rudiments of a fair hearing that is required. And secondly, what if you don't? What if you say, well, just don't do it again? If the commission is not willing to enforce its rules of decorum, and then you
30 seconds, Mr. Todd. Sorry.
If you don't punish bad behavior, you're going to get them out.
Response?
I'll start with the line again. If you don't punish their behavior, you get more of it. So my emails and communications, I have never regrets them because they are motivated, everyone, if you look at them, out of a continued issue here where right now, I don't even know what motions you're going to consider. I don't know the basis. I'm not allowed to have the same kind of relationship on those things. It's completely unfair. You've seen it with the order, and one of the emails I did when that order's not being complied with. You've seen it when Mr. Bray sent a note to all of my witnesses telling them basically don't work with him, he's an evil guy, to my witness list. That's one of the emails in there. So the issue with this body sending emails. I never sent an email to anybody until I think May 18th or something like that. And it was in result of, I had in writing from Mr. Richter what motions were going to be heard in a hearing, and then he told me just they're not going to be heard. You know, this is a great example of this particular motion. I was not served this motion until the 21st. Okay, I told an all-nighter to write some response. I don't know if you got the response, but you should had a chance to see it, read my response. There was another case when I had a motion to compel earlier on in this, where Mr. Gregg was given 30 days to respond to a motion. So at the beginning of mine, I put an objection on this whole motion that I haven't had time to respond. Now, this is not fair to me, and I have no regrets for communicating when constantly these things come up, where I don't even know what motions are going to be heard. I'm told motions are going to be heard, then told they're not going to be heard. I don't know whether I can cross-examine Alan Freeman. Another thing that I had printed out on the list is the vast majority of the witness subpoenas haven't even been served.
I think
So-
we should limit ourselves to the scope of the first motion, as opposed
Okay.
to all of them.
My point. I appreciate that. The issue here is a constant lack of information to me that makes me concerned with the fairness of this process. Now, ultimately, for Mr. Brace, did you guys get my response? Okay.
Yes.
So, I mean, I literally pulled an all-nighter to write it. He claims he sent it to me at an earlier date, and like on the 15th, which should still be a week to respond. I didn't get it until the 21st. And the funny part, excuse me, of lying is, you guys know me, I respond to all these things immediately within a couple of days. So the notion that I intentionally, well, say something, is completely false. I haven't had adequate time to prepare for this motion. I don't think it's right, because I looked at all of his cases. I went through and tried to examine all those cases, and I apologize for errors I made. I'm not a lawyer. There were 15 case citations. I always dig in deeper when lawyers put a lot of case citations and stuff, because usually they end up being off point. And there were ridiculous examples of malfeasance of a board, like a commissioner announcing their verdict and leaving in the middle of the hearing. A deadlocked vote, where then they removed a commissioner and put another commissioner on, and re-voted when the person hadn't even been in the hearing. A body that had no transcripts. Several cases that involved jury tampering, where communications were secretly made with jurors, et cetera. I think a lot of the stuff was not on point. And his whole arguments about the statute and the rules don't hold up. He applies things about hearing to other communication. The reality is, I have not had a discussion or communication with any of you. There's no interaction. One of those cases was the Patco airline strike, where the board members were having dinner with people that were involved in the case. You know, we're one of his examples of this. When you get down to it, I don't think, in respect to Alan Freeman, that there's anything that has happened or that you guys have done, or has happened in this case, or any communication that would imply that you or any of you towards Mr. Freeman have shown bias, partiality, or prejudice. I don't think there's been any example of that. If anything, this commission has bent over backwards. I've come here, you know, I like the better on it, but I've come here countless times because there's always these motions, but we never get to the facts. And I always am left in the dark, and I'm getting, you know, I don't get time to respond.
30 seconds.
So I think that there's nothing in this case that would in any way imply that you're not capable of having a fair hearing and having a fair decision based on the facts. And one thing you notice in all his case citations, I think they all entirely, except the one about having a chain meeting of a public body, they all involve somebody appealing after the fact with an exact case for what was the bias that happened in the decision. I haven't seen anything from you guys that shows that you're unable to have a fair, unbiased hearing and make a decision based on the fact. I think the motion should be denied, or I can give it time to actually write a competent response versus an all-nighter. I apologize.
I guess my first question is, and I'm a litigant for you. It's either we're going to make a decision today on the motion, or you're asking for.
Make a decision based on what you know.
Now, I have a question for you, Mr.
Yes,
Fix.
sir.
And I would agree with you that I don't think I'm biased based upon your correspondence with me, because I think what you were putting in your emails, I was seeing in your motions, so it doesn't affect me, it doesn't change my opinion. But after you were told by Mr. Richter to stop corresponding with the commission members, why did you continue to do so? And if we had this continue in the future, what are we supposed to do with people who don't follow the rules?
I think I'd have to look at when Phil's note was, it said that,
Why?
which I objected to, by the way, I responded. Now, but
appreciate the
let me, I'm trying to answer your question, okay? If you look at the notes, they are continually because of a lack of communication to me, a lack of clarity, a lack of follow through on commitments that are made as a motion. You guys need to be aware of that. What am I supposed to do? If this was a court and I was a lawyer, we'd be having a conference, we'd be having a sidewalk, we'd be doing something. What we're supposed to sit up at when these are not. Yeah, they might need up saying. Your.
Child to follow the. You don't do this. The parent is supposed to do. If you don't follow the rules and you're told not to correspond with commission members, and yet you continue to do it, what are we saying?
Actually, records. You're doing anything wrong. That's an example of his note. Okay, so just that I shouldn't do it because if, and this is what was in his note, I'll paraphrase it, Mr. Ricker, if I have to read from the note or I can find this. He said that if this continues, there could be more members that need to recuse themselves. So what I also put in my motion is if any board member here feels that they're unable to make a fair and impartial decision based on the facts that they have bias, partiality, or prejudice, then they should recuse themselves. And what's not like to be in this communication that board members might need to recuse if they feel that they cannot be impartial. That's, you can read the note, that's the, what is exactly the note from Mr. Ricketts.
Are you finished?
Yes, let's be like the other way.
Any questions?
Mr. Beatty?
Go ahead.
I'd like to say a couple things. One is, for Mr. Hicks, you cannot communicate directly with the commission. I want to make that very clear. You cannot do that. Mr. Fry uses the examples of what lawyers can and cannot do. Lawyers cannot do that. Pro se litigants cannot do that. You cannot do that. So if there's any question in your mind about what the executive director said to you, I want to make it very clear, you are to have no direct communications. And just because it's not an interactive one, doesn't mean it's not a communication. When you put us on your email, you can't do that. That's just, pro se litigants, some of us here are lawyers and involved in litigation, and they do get some leeway because they're not licensed lawyers, and we try to make sure that that happens. But they are held to the same laws and standards and everybody else is, including the lawyers. I think Mr. Fry is correct that he can't respond to that because ethically he knows he can't. We give you a little bit more discussion because, as you said, you're not a lawyer. You're trying to figure it out as you go. But if there's any lack of clarity in this, I'm going to be absolutely clear. You cannot have direct communication via email or otherwise with members of the commission. Now, that being said, when it comes to Mr. Fry's motion of somehow that the commission members were unduly influenced or biased, I will tell you from my personal perspective, whenever I have any party before this commission, email me directly. Once I don't read them and I put them away, I have never read any. I read, I think, one way long ago, but after that, I don't read them. And I also assign it to my junk mail. And so when I saw Mr. Fry's motion, I was actually surprised that we've been communicating this so many times because I wasn't even aware. After I mentioned it to Phil, I'm like, we haven't been communicating with. He goes, oh yeah, you've been on these emails. I'm like, well, I don't know that because I don't read them. And the reason I don't read them is why we're here today, because it really isn't fair for somebody to send us information that's not in the motion, that's not publicly available, even if you copy the other side because they're prohibited from doing that. So I just want to make it very clear, I don't feel like I've been biased or prejudiced by it, but I'm a lawyer, so I sort of understand that this is the process and it's supposed to be followed. So from my perspective, I don't feel that it's unduly influenced me. I don't know about other members, they can speak for themselves. But I want to be very clear with you that you really can't do that.
Brady, I also want to share that, I'm not unduly influenced by any emails. I didn't read them. And I call myself non-JD impaired. Individual. And so I know from common sense that you don't take into consideration. I just want to for
I wrote before, the judge may take action such as throwing the case out if failure to follow the rules. And I'm concerned, and maybe this is directed to Mr. Ricker. What avenues do we have should this conduct continue as a commission?
Well, I think the only avenue that we would have is, Mr. Nixon indicated, and I indicated in my original email, were you to feel you were impacted by it, you would need to accuse yourself in consideration. That's where it would apply. When I originally saw this email or saw I indicated the less than one of all of you get back to me and said you were unduly impacted. Otherwise, I'd be recommending dismissal because I can't know what each of your respective minds are as it relates to this. But knowing you as I have from having worked with this people, I didn't think that you from this kind of contact, which indicated be here, be unbiased is stuff. My recommendation is I'm sorry, it's not a motion. Because, some of you already said it, and Mr. Brown, you have indicated that you well, so I was appropriate.
I just think for press, this is the first time I've experienced this in the 5 years I've been on. But if somebody doesn't comply, maybe the potential should be that there are refusals and you can't get it. The first time it's occurred to me in 5 years.
Well, I'll just briefly add, over the 25 years that I've been doing this, I've only really had one or two members ever get back to me with comments that they had been contacting in some manner. And their indication to me at that point was that they told the person, aside from the meeting, and they referred that person to me. So it has been a rare occurrence for me.
I guess I'll go on record as saying I didn't influence my emails either, just because I don't read them and it's to my work email, which is on my work, so. When I see that come through, obviously it's not part of, what should be coming through my work email, so it's been disregarded.
And as Mr. Richter indicated when mentioning me, I likewise was not influenced by an unsolicited receipt of email that I certainly never responded to, nor would I ever believe that that constitutes a discussion. Again, for the record, it was not included.
Anyone else?
I move that we deny the motion.
Second.
Do a roll call?
Yeah, please.
Okay. Ms. Green?
Yeah.
Mr. Brown?
Yes.
Ms. Kaufman?
Yes.
Mr. Morris?
Yes.
Mr. Norman?
Yes.
Vice Chair Bailey?
Yes.
That motion passes seven, or, excuse me, that's right. Six.
And, okay. Next one. Motion to amend the law of personal knowledge or to limit. And that means limit the hearing to the items contained in the complaint. And you will again abide by the
Thank you, Mr. Chairman, members of the commission. Our second motion to dismiss is in the alternative, and actually there are sort of three separate items that are addressed in. First, to limit it to items not pled in the complaint. Because obviously nothing that wasn't pled in the complaint factually was based on personal knowledge. Second, to dismiss the second complaint, the one dealing with Luke household, because the one dealing with Luke household fails to specify all the elements for a prima facie case of any violation based on. Third, a motion to dismiss the first complaint, the one dealing with the 6 invoices that were sent not to respondents, but to somebody else. Because once again, we claim that they were not prima facie case based upon an affidavit. Complaints have to be based on personal knowledge. It's a statutory requirement. This is a breach of statute. And our recommendation is a requirement. We don't have jurisdiction. You don't have an affidavit based on personal knowledge. And personal knowledge has been defined by the court to mean first-hand knowledge, not second-hand knowledge. Usually they're talking about personal knowledge in Rule 56, motion for summary judgment, personal knowledge requirement of extraordinary that's filed with the Supreme Court. There hasn't been a lot of litigation about personal knowledge, so it's the same term, and therefore has the same meaning when it comes to how election schemes are cases. Personal knowledge has been defined as Franklin County Court of Appeals. It's knowledge of the truth in regard to a particular fact or allegation which is original, and it does not depend on information or hearsay. This, by the way, is not a magic word. In other words, if you don't say what basis it is, you might still have personal knowledge if it is apparent and specifically demonstrated from the face of the complaint. For example, he says, I went to the Secretary of State's website and saw this campaign finance. That's personal knowledge of the campaign finance, even if he doesn't say it. Or that, on the other hand, if you don't have personal knowledge of something, saying, I think this happened, well, that's not personal knowledge. Thinking is not knowing. And when affidavits state a basis other than personal knowledge, you presume that it's not personal knowledge, and you should reject that complaint, or at least that portion of the complaint, if it does. Now, the affidavit of a complaint has to clearly set forth the specific basis, contain all affidavits and cases and documents relied upon, and clearly set forth sufficient facts supported by affidavits constituting violation and set forth every specific allegation. The only allegations in the 2 complaints are about Luke Householder and about the 6 invoices sent to other people for broadcasting for the benefit, presumably, of Allen Green, if the invoices say what they appear to. Having said that, that's it. That is what the hearing ought to be about. It shouldn't be about, let's find other facts that were not pled in the complaint, our personal knowledge or otherwise, that we can expand the hearing into a surprise. Today we're going to say you didn't file this other report, or you didn't file some other expenditure that he had no personal knowledge and claim no personal knowledge in this complaint. So that's what we would urge that you accept at least that portion of staff's recommendation, that we limit the complaint and not allow it to be kind of a free for all allegations you can come up with that were never pled. I said it can't first constitutional statutory claim. Second, the affidavit about Luke. He believes that Luke Freeman or Alan Freeman's committee violated signature. He states that his personal knowledge, he actually saw Luke House in a hotel room. He saw Luke House doing some work for or showing campaign events for Greg Humphrey. All that, that's personal knowledge. He actually saw. He doesn't say he has any personal knowledge that Alan Freeman's campaign paid for him or somebody else paid for him as an intangible. He speculates. But he claims nothing in his affidavit. He said, initially I heard rumors that Mr. Household was staying in Claremont Hotel. And I went down there and looked for a vehicle in his place, took a picture of it. I saw him staying at Days Inn, and I saw him at other campaign events. Okay. Now,
Excuse me, I'm sorry, I looked away from mine. You've gone over your 5 minutes already. Resume or quickly finish.
The affidavit, it doesn't say any personal knowledge of the violation of the household. The affidavit regarding the 6 invoices that were not sent to Alan Freeman, they were sent to strategic media placement, political NCC. There's no allegation of personal knowledge or otherwise with respect to 6 invoices as to what they are, who they are, whether the amounts are accurate, whether these are entirely for, they say they're not entirely for the Freeman campaign. It doesn't say who they are for and what amount, or any evidence that Alan Freeman or his campaign ever knew about these expenditures or whether they were spent, or in part from the fact that in the household. There are ways in which caucuses can spend money on people doing multiple campaigns and never have to report anything.
If you need it, you have.
I don't think Steve, I think I could take another 5 minutes. I think,
I certainly won't sit there and say, Mr. Hicks, in 5 minutes,
Right,
we're
yeah.
done.
Okay, good. So they,
But
I just, I'll get to deeper quickly into this, but I just want to give an example of this constant. By the way, there was an order on July 21, 2021, because of Mr. Bray's constant trying to separate these, get the 2 affidavits, get one of them stopped. So the director issued an order saying this is one case, these things go together, and this is what we're proceeding with. Now, I would say that my affidavits point to, if you look at the rules for an affidavit, what was the personal knowledge, and then what was the crime that's alleged to be committed. So these sometimes conflates those 2 things with what I see, what did I find out, versus what's the crime. Ultimately, the allegation is about massive media spend that took place that was never reported, about resources that are working for a candidate that are never being reported anywhere. Like Blue Council was not an ORG resource, it was a constant content resource that were reported in any campaign finance system. Just to give if you would go with Mr. Bray's logic, it would say there should never be any investigation into any thing that comes before the OEC, because if you didn't know everything on day one, it cannot be considered. I want to use the 6 invoices as an example. I put forward 6 invoices specifically from the FCC database that were based on, I live in the district, I saw these commercials, I saw on his Facebook page, him saying, did you see my commercial on TV? Then I investigate, because nothing's on his finance report, I find all these FCC invoices. As we all know, I came pretty close on the media side, I found $118,000 worth of invoices. I would say during the investigation, after we had the preliminary review, reported actually 138,000. They also had an affidavit saying that they had paid the invoices on behalf of the Freeman campaign. So then we found out that there was actually that's still been hidden from me in disclosure, a set of communications of an invoice of $298,000 to the campaign. One of the things that's I think very important is an affidavit is based on the fact that you know that you saw personally investigation up to that point. But then once it goes into the hearing, there's discovery. There's lots of things that come out of that. And Mr. Bray now wants to go back to, well, you can only talk about these 6 invoices because of, we found so much more stuff. On the case of the resources, I don't know what more I can do to confirm that Blue Councilor was doing work for Alan Freeman, being paid and never being reported anywhere. I mean, I staked out the hotel he was staying at. They have personal knowledge of that. So the bar that Mr. Bray would suggest is ridiculous. And I feel like a lot of this is also deja vu all over again, because a lot of these things are very similar to what we did at the last meeting with Gene Schmidt and Ron O'Brien around these things. So obviously, I think the motion should be denied. I think it would be utterly inconsistent with just what happened with Gene Schmidt. The next thing that says the motion would be accepted. And I don't know what else a citizen can do to have personal knowledge other than what I have done. And I don't know by what standard you would have that, for example, if a police officer had an affidavit. And then it was found instead of 2 kilos or 10 kilos or something, well, you can't. So I think the motion could be not denied. I think a lot of this is going to go all over again. And the last thing I will add, how am I doing on time?
You're fine.
Okay, last thing I'll add is, Mr. Bray likes to talk about surprises. Well, we already had to submit all of our exhibits on August 11th, so what will be a surprise? I put forward to Mr. Ricker that there could still be some additional things, but the exhibits have already been submitted. So what's going to be the surprise? So you're worried about a surprise. It's all already been put forward to the exhibits that we're doing. So I think the motion should be denied. And we should go forward. You'll back on that.
Well within.
The motion.
I'll move that we deny the motion to dismiss based upon personal knowledge. I mean, consistently, we as a commission have dealt with pro se litigants, and I think at least on the space, we've got enough here where we can proceed. We've already made a decision, set it for hearing, so it doesn't change my mind. So I would move that we dismiss that portion of it.
Let me stop for 1 second.
Yep.
Given that this was a motion alternative, the separate motion for the portion of the limit scope.
Yeah, I wasn't addressing that in my motion.
Okay.
Mine just dealt with just the motion to dismiss itself.
Okay.
Second.
We have a motion of, I will do a roll call, if that's your preference. Mr. Brommer,
Yes.
Ms. Kaufman,
Yes.
Ms. Cunningham,
Yes.
Ms. Tavares,
Yes.
Mr. Norman,
Yes.
Vice Chair Bailey.
Yes.
That motion passes 6-0. I got the number right there.
And do we have a motion on the alternative portion of that particular motion? As to,
I have a comment before I make a motion,
okay,
which is if you file a lawsuit or you bring a claim such as you're going for this commission, whatever you have pled, that is the most you can recover, and that is the most you're able to pursue. So I think Mr. Bryan's motion, although if we were in court, he wouldn't have to make a motion. I think it needs to be limited in my motion. I would move that we limit the hearing as to the allegations and the complaints.
well, and I think in the spirit of Mr. Hicks' question comment regarding understanding the scope of what's going to be addressed in the future, that motion, helps the comments.
I'd like to hear Mr. Rickon.
I would tend to agree with that. I think this commission is responsible for complaints that are brought to it and for it, and the allegations that are contained therein, and that is what we make finding on. If through this process, Mr. Hicks has come into other information that may invoke other elements, even though they're similar, he has an ability to file another complaint based on that information that he was subsequently developed. At least that would be the approach I would take. The approach I would recommend.
So this sort of, so I can understand from a legal perspective. The review is that the statute would require that we specifically need all of the items of evaluation. If discovery if through discovery you discover more things than that, would you, could you, should you amend your complaints to comply with the evidence? Or you're saying if it wasn't pled in your original complaint, you're not barred by race judicata for anything that you discovered in this case that you might be used to be from another?
Because, at least to me, because that would be a different set of facts and circumstances, separate and distinct from what was originally pled in the complaint. Yes.
And I think it's the civil rules call for either seeking leave to amend your complaint, or if you're not time barred, you could automatically file the amendment, but we've not had any amended complaints to bring additional allegations.
And I will inject that as a general rule, because we have dealt so rarely with amended complaints, I would generally recommend that somebody file an additional, file a separate and distinct complaint, which depending on when it is filed, we can consolidate it potentially, depending on when it is filed, or we conduct a separate preliminary review hearing based on the second complaint and the evidence that's included there.
Even if the violation is basically what is, it's the same similar violation based on the same people?
Yes, because it's a different set of, there are different facts and circumstances of what's important.
Yeah, okay, so I'm just, just as a,
Sure.
I'm just struggling a little bit with the car filing complaint, that you violated campaign finance law #1, and here's 6 examples, but I didn't name all the examples, and I discovered more through discovery. From your perspective, the complaint is limited to the 6 I cited, and I either have to amend my complaint to add more, or I would not be barred by res judicata for things that I discovered in this case on the allegation I complained about, to file a second thing for a similar violation for additional items that could have been brought up in my first one based on the discovery.
But because they were not brought up
In
in
my
the
complaint.
original complaint, they are new and distinct and separate allegations.
Okay, and I can't do a motion to conform to the evidence or to conform to discovery to keep it in one place? I mean, it seems like counterintuitive. I'm just,
I guess the problem I perceive with that is due process to the respondent. Whoever,
right,
all of a sudden you're hearing and they're bringing up random allegations that you didn't know were coming in your face.
understood.
And I think that's the purpose for saying you've got to limit to the allegations being raised in the complaints.
I get part, my concern is about the next step. Then at that point in time, are they barred from ever working on something?
Hold on for a second to withdraw comment on this because.
My argument would be no, because it's not a matter that we had previously addressed.
But res judicata does, it means you did or should have, could have, it didn't. It doesn't mean just what you brought up, res judicata or anything that was based on the same facts and circumstances that was raised the first time. That's my understanding of it.
Okay, that.
But we're a statutory court, so maybe not.
Well, that's different. How we have ever operated
Okay.
in the past.
And I think there's also an issue of the discovered will do or should have known. And if you
Right.
don't know it all, so you discover it, you didn't have it before and couldn't have had it before, that would change whether you're barred from bringing that up again.
In the same or future litigation.
Correct.
Okay, just wondered.
Okay.
It's
That's,
a very technical view, I think, but I get it too.
Mr. Hicks, your question or comment is on this particular.
I suppose procedurally would be Mr. Bry first, since it's this motion. Do you have anything further?
Well, I obviously support the motion. I think that it's one of the challenges we've had is knowing what it is we're arguing. And keeping to the point, I think, is important for arguing process. Yeah, there are a lot of exhibits, but who knows what actually Mr. Hicks, or he may not know what I'm going to say, not understand. But whatever we say, I think legally, is required by both the statutes and the rules of the process to be limited to one public.
Is your comment for, a particular motion, or are you looking for guidance based on the way you see it's going?
I think it's, the comment on the particular motion. I think they look at blend together. So, I want to comment.
1 minute.
So, I just want to think of the preposterous notion. I'm going to get to a point of that what we're talking about with grace would be, for example, that I've said 6 invoices under $80,000 and then immediately found that SMP said they paid $138,000. But now that can't be included because, just the preposterous nature of, it's not as if I introduced my allegation, maybe just spending that was not reported and resources that were not reported. My allegation was 6 invoices. Okay, and the actual affidavit required you to specify the facts and evidence you have and what is the actual allegation you're making. And so I think my allegation, and resources reported. The notion also that it exists, and I would have to keep refiling additional motions is ridiculous, especially if we can't do these meetings. Okay, just the amount of effort it takes to do something. So I would say that either this motion should be denied because you already have the exhibits, you know what I'm going to talk about. So doesn't go off the point, it's already submitted. These motions should be denied. If it's not going to be denied, then I would ask that there would be a continuance of the whole case so that I can make the complaint conform, so that I don't have to go through another year-long process to get to the same thing we are right now. But the notion, I think, is a very dangerous notion, the concept that somebody made a specific allegation, like, for example, unreported media spec has specific evidence, and then an investigation uncovers the exact numbers of that, but you can't consider the exact numbers. That doesn't make any sense. But it seems like a preposterous outcome for how the elected officials would work if that were the manner in which they would say, why even do discovery? You have to know everything up front. Why even do discovery? To pinpoint the numbers and the facts. So that's side of the motion be. Otherwise, I think the case should be so that and my complaint, or this that's the issue like pleading the fifth is figure out this is not a quick answer because it has long-term implications for the investigation during the investigation period that pinpoints not. Thank you.
May I respond to a motion he made as part of his remark?
Well, I don't think we're gonna
Okay.
let this gravitate toward outside of what we are dealing with. So, is there a motion?
There was a motion placed to, to sustain the motion to limit to the elements of the complaint.
I'm going to withdraw my motion only because I think we need more discussion. When we're talking about a civil case, we generally say leave shall be freely given to amend to make sure all of the allegations can be heard and brought before the court. And Mr. Hicks is asking for leave to amend his complaint because there's more that he feels needs to be addressed. I think we as a commission should consider that. Because as we know, he's limited to what is being pled, and that's what the motion was. But if he believes that he has more evidence and he has more that needs to be amended to include in the pleadings, or in this case, his complaint, I would be a proponent to say allow him to do so.
Go ahead.
I respond to that suggestion. A motion to amend in connection with the Ohio Elections Commission would permit him to create new allegations without the new preliminary hearing. In other words, we would still have to go through a preliminary hearing in order to determine whether or not those new allegations were proper. And it would not actually save any time because we still have to go through the same process. We have, this case has been going on for about a year. This is the fourth motion here we've had with full commission, that's in the recusal. It has cost my client a huge amount of money, and we would like to get this case done. I would respectfully suggest that continuing this case and allowing additional amendments, we're not really following the point ones. And we'll deal with that, but he will then. He's limited to the facts of the complaint. And you can't do a bunch of different things that aren't related to it, or try things that aren't related to it. I would like to get this case done. It has been costly and prejudicial to my client in terms of time and energy, and to allow one more continuance. Something else can change entirely what this case is about. It would seriously prejudice my client.
If you filed another complaint and filed a motion to consolidate, wouldn't that actually do the exact same thing?
No, because if you almost hopefully this case is going to be done, and we're going to have maybe we'll have preliminary. I would question whether it's really an interesting commission is thing right on. Just put a complaint, we'll try. We'll try. What to allege in response to that? Because right now, we don't, and right now, given it. If we allow the amendment, we're not going to try the current case in 2 weeks, and we're not going to get it done.
I would respond. Hold on, with that being said, would you want to withdraw your motion?
Right, to limit the case to what is in the complaint, and I have no intention of withdrawing.
I think it's a little bit needs to be seen through. Mr. Ray wants to save his client money by having me file extra complaints, extra affidavits. It doesn't make any sense. The allegations in this have been very clear. Asking me to spend resources that weren't reported. I've never deviated from those allegations. I've never had other allegations. I've never put thing. The notion, this motion was filed on September 17th. September 17th. If this was this motion developed months ago, to do this is just a tactic because of the eminence of the hearing. And I think we're talking. So it's, I'll take less, I'll try to take less. But the notion that, I keep bringing forward my allegations and affidavits, I'm not going what the personal knowledge was, what's the specific allegation. The allegations were about management and it wasn't reported, and about research not reported. I think I've stuck completely to that. The irony of this is, since August 11th, you've all had my exhibits. He's had my exhibits. You know exactly what I'm going to talk about, exactly what I'm going to focus on. I think that if Mr. Bray wants to use this tactic to hamstring under the guise that he's going to save his client money by making me file additional things, I think it's fair for me because those additional things would take time, and I will absolutely do it. So I think that either this should be denied. You already have the exhibits. There was already an order around this to deny it. But otherwise, I want time that I don't want to have to do a whole different set of streams of cases and preliminary reviews. You probably don't want to see me coming here doing cases and preliminary reviews. So it would certainly save us time and money then, because they need time to amend a complaint so that this can be properly fully considered. And the net result is that it's gonna just take more time. Either way, either I'm filing more affidavits or I an affidavit, it's just adding to all this, and it's a day late and a dollar short. I think it should be denied because for my allegations have never changed, and you've already had my exhibits with more than one.
Well, I differ with you only in that, and I don't want to speak for Mr. Bry, but I'm guessing this motion because he wanted to continue to go off on the reservation, all of these different issues, which don't pertain to what you have actually put in your complaints. If you were sitting here and you're honestly telling this commission, you believe there are more allegations that you need to amend your complaint to actually bring in, then I would not be opposed to granting leave to amend. If you're looking to just extend and keep doing a bunch of stuff and going off the reservation, I'm telling you as a matter of law, you at this stage, I believe, are subject to only which appears in your complaints.
The allegations or the specific evidence I got.
The allegations, what you have raised as the violations in your complaints.
So the allegation of my complaint wasn't 6 invoices. The allegation of my complaint was that there was massive.
I'm not looking for a debate. I'm asking you, do you believe you need to additional allegations in an additional complaint? Or are you comfortable living with the allegations you have raised in the complaint you have filed?
Is the allegation, and
You're not answering my question. You're
Because
giving
I'm-
it
because I'm-
your butt.
Can I ask for clarification on the question?
You
So
have
the-
filed 2 complaints,
So the,
and what you have set forth in those complaints are what we as a commission are going to hear. That's it.
but his definition of that is 6 invoices. My definition of that is massive media spend that was not reported. That's why I'm confused by you asking your question in that way. So the definition that I think is that my allegation was massive media spend that was not reported. My allegation was resources that were being used that were not reported. That was my allegation. I offered evidence. You get into the circular reference, was I supposed to offer evidence I didn't have? That then he would say wasn't personal knowledge, so I put it in there.
So we can legal counsel to you. What you need to do is
I can't have a clear question.
hire counsel to assist you, or know that if you proceed forward, motion, that you're limited to what is listed as the allegations in your complaints.
The allegations are just 6 invoices.
I'm not here to provide counsel to you. I'm telling you what we as a commission are capable of doing.
And I would ask, maybe you should all pause and read your own mission. The notion that you won't answer a question is, does your motion mean the 6 invoices only, or the allegation of massive media spend? And to tell me I should go hire a lawyer to get an answer to that question, I think it defeats the purpose of this being a body that's supposed to be making it easy to get resolution, proper and fair resolution on campaign finance issues.
We're here to make decisions. We're not here to provide advice to you.
Can somebody
Yeah, your
answer?
simple question is, what is the definition of an allegation?
Right.
In the 50%?
6 invoices or massive
No,
media?
no, no, not that. I'm saying, you're asking, is an allegation the claim of wrong generally that in statute, or is it allegation means a specific subset of factors? And,
Correct. Now, your own- what your purpose is your job. And supported by your. Discovery and investigation. You ever done this discovery investigation, if the actual amount was $138,000. The logic would be that it has to refile something, or has to amend something, or has to do something. I was unaware, this has only come up since September 17th, we filed this motion. Okay, it's part about limited, it's already come up after you had the order, when he was trying to get behind the scenes, get rid of certain important things. Record issued an order. So. The only is that. Okay, yeah. I don't want to seem like a program director. But I've never gone through the 3 things that were my active obligations. What's happened is more evidence has come into light and covered light, and it was like this, strategic media said it was 138, not 118.
Then I believe you answered your question. What an allegation was evidence. I mean, as a layperson. So if, Mr. Norman is directing me to kind of investigate what an allegation truly means, Mr. Vice Chair Beatty, that's the answer. So we can delay it for an hour more, or we can.
Well, I just want to make a quick comment. I apologize, but, he's got a lot of words in his thing, so when you're making motions and agreeing to something, I'm very careful about what might be in something that he wrote in something that was submitted on the 17th that may create an implication that's not maybe the intent of this commission as to what it means. So I think we need to be specific because he made representations in his filing as to what these things mean. And a vote that to accept that might be implied is meaning whatever he said in his thing is true, accurate, fair, or
May I just respond briefly? This is a quasi-civil, quasi-criminal proceeding. And therefore, respondent who is potentially charged with criminal conduct has a right to know not just the statute, but the factual basis of it. The rules of this commission require it, as well as the statute, that there be a prima facie case, which is facts, that support an allegation of the statutory violation. In a criminal case, if I were accused of breaking into Mr. Smith's house, and they found in the course of their investigation, they also broke into Mr. Jones's house, they would not be able to present evidence and convict me of breaking into Mr. Jones's house at the criminal trial in which the criminal complaint accused me of breaking into Mr. Smith's house. They violate all kinds of due process to require me to be there as someone who is potentially facing criminal referral. I don't think that the amendment process, I think the reason the amendment process is not going to be often in the Ohio Elections Commission is because it's inconsistent with the rules of proceeding in the Elections Commission, unless both sides agree to amend, which we're not doing. Because the rules of this commission require when you make a new allegation, a new factual basis for violation, that you have a new proceeding. You might be able to consolidate new time with that. And by the way, if it does make new allegations, new complaints, we would have an opportunity to try to knock them out. And the defendants, and they were new. And frankly, I'm willing to take our chances on doing it. But that's not going to happen if he somehow is able to avoid the procedural requirements of the new allegation by amending it or in the eyes of the amendment, avert the need to present that factual argument in front of the board before anything was happening.
Potentially that raises if they're not consolidated, you have two hearings with the same set of facts, the same set of witnesses. And this commission is, instead of consolidating, and basically it's a jury on two occasions with different commissioners, because at the end of the year, you're going to have three commissioners who are leading this commission. And so it seems to me that either you file your complaint, consolidate, or you amend, it's the same result. If Mr. Hicks actually intends on filing the additional complaint or seeking leave to amend, should be granted so that you're not getting inconsistent results with different commissions.
I have a 30-second response. So he gave the example of Mr. Smith's house and Mr. Jones' house. Great example. I love it. He broke into Mr. Smith's house and stole a bunch of stuff, and then Mr. Smith reported in an affidavit to the police, these are the things that I got out of my house. And then later it was found, oh, the guy who stole from your house also had a diamond ring. Oh yeah, that was my diamond ring. I didn't listen to my affidavit. I don't really have to put from a, we just say like, well, we can't do anything about that. He gets to keep the diamond ring. We're not talking about unrelated things. We're talking about a very straightforward allegation of media spend, all involving the same people, SMB, Allen Freeman, et cetera. The other thing is he's that prima facie case. So I don't know what that meant exactly. I know what it means generally, but so last time we were here, he was arguing about an affidavit needing to show just probable cause. So the different use of definitions, obviously my affidavit showed probable cause in a preliminary review phase. Then there was discovery and an investigation. And then that just, I don't think the exact allegations that were in there, like that it was 138,000 versus 118,000. The idea that that requires different complaints, consolidated complaints, that you always have to amend if you find something, would make, look at how this case has worked. It would make things here take decades to get anything done. And so I think the right answer is just to deny the motion but like I said, if you're not gonna deny it, then I want to have the opportunity to consolidate, so I don't have to go through everything all over again for a year, that I'd rather take more time and get it all consolidated now, but I think the right answer is to deny the motion.
Okay, hold on.
Go ahead, Arnold. I'm sorry, I didn't mean to
No,
interrupt.
no, go ahead.
I think you need to reflect on what you're saying, Mr. Hicks, because if you're saying the motion, I think as a matter of law, you found what is in your complaints. And so if you want to proceed with what's in your complaints, that's your choice. If you feel there's more that needs to be added to your complaints, then you either need to seek leave to amend or tell this commission that you'd like a continuance, but you're just going to file an additional complaint and you're going to ask to consolidate.
I think this is our confusion on my allegation with the master is that I presented information to gain probable cause. Then there was discovery and investigation. We found things like that instead of 118,000 of the 138,000. The notion that that requires all this extra work would make this commission unable to function.
Well, we've functioned for years.
I think these kind of cases, you're probably going to be the road referral and stuff like that. I've said before, this is a canary in a coal mine of more complex cases where these factors come into play. And I think that for the state of Ohio, and given the issues that have happened in campaign finance, beyond this case, this commission needs to figure out how it's going to deal with those kind of things, because we desperately need a commission that can deal with these kind of more complex cases.
Mr. Hicks, it's pretty simple here as we sit here looking at you. You either need to say, I'm prepared to proceed with my complaint as it's prepared, or I'm asking to amend, or I'm going to file an additional complaint. That's the only issue facing you right now. I don't want to hear any more argument about what else is the facts and the change in money. What do you want to do? What do you intend to do?
I am prepared to proceed with the exhibits in the case that I had to submit on August 11th by order of this commission. I have had no objection from him or anybody else about what I submitted for that, and so that's what I'm prepared to proceed.
That was not one of the key things I think that Commissioner Norman said. And clearly, Mr. Bright is objecting to those because he has a motion today to leave the complaint and the 7 invoices attached to that. That's what's before the commission. 6. If we grant this motion, you're limited to a complaint and 6 invoices.
Well, he just said it's very,
If
you deny the motion, now I'm limited to that. So I'm being as simple as I can. I don't know how a person, I think this commission needs to get latitude, but it needs to work. It needs to work you need to look at what the mission says.
So, okay, stop. The latitude we're giving you is this, 2 choices. 1. We'll rule out the motion, and if we grant it, you're limited to the complaint and 6 invoices. If we grant this motion.
Okay.
Or Mr. Norman is saying, if you're saying that's not what I want, you can make a motion to continue the case and leave to amend or to file an additional complaint.
If you deny this motion, so you said if you grant
No.
the motion.
No, what you not that I'm telling you. His motion is to limit the hearing to the items specified in the complaint. If we grant that motion,
Yeah.
you are limited to the items specified in the complaint and 6 invoices.
I think you should deny that motion.
Okay, if we deny the motion, Commissioner Norman is saying, you're going to be limited to what's in the complaint.
You're just saying it's the same thing, then I understand.
It's the law says.
I'll tell you, Mr. Hicks, that is a motion I would put before this commission if you are not seeking a continuance or a motion to amend. I just need an answer because I'm ready to put forth my
What you're
motion.
saying is, I just want to be clear, no matter whether you deny or don't the motion, but I've just had to explain it.
You haven't heard
It's
his
a
motion.
thing. So I think, I do whatever you want. I think Ohio needs to see how this commission is going to work. And the notion, for example, that after that, I've said it again and again, my allegations were very simple. After me, that wasn't reported and resources that weren't reported on any campaign finance report. I presented probable cause and affidavit in a preliminary review I provided evidence and I made those specific allegations. In the discovery period, we discovered that the number, for example, was 138, not 118. Somehow that's some complex thing that we have to, that either I have to amend, I have to do this, I have to do that. Do whatever you want. I feel that the case should proceed with with the allegation, which is massively and the evidence that is obtained during discovery. The notion that that needs to create a new case or consolidation to me would be an absurdity.
That's the law. And I'm giving you the chance to unring the bell before I ring the bell and say,
Do whatever you want, Mr. Long.
I'm giving the opportunity, and I'm gonna put it on the record. I'm giving the opportunity to ask this commission for the opportunity to amend my complaint or file an additional complaint, should I think there are.
Well, I would wish to, be able to, file additional. Adding extra little things.
That's already been discussed earlier in the very beginning.
So would your action on this motion have any impact on my ability to file additional complaints?
No, and that's what the executive director explained in the back and forth of the commission about how this could potentially go.
So in theory, you should point of clarification. I think with all my complaint, I'll do complaint
You could have.
Yes,
after you make whatever decision you hear. I just think you guys should talk without us talking about what's the intent of how this, you look at your mission and you get the idea of what you're supposed to do. It's just to figure out how do you want this to work going forward, because I think the notion that 20 feet versus 138 is my great example. That this requires this kind of discussion for this long is the point of absurdity.
Just one, I fully support this suggestion to use for us.
And you know what's coming back, so if you're interested in saying your client money's to look for.
Can I ask a question as a layperson? What is the difference between withdrawing and then submitting a new or amending? So the amends, is that maybe not as laborious,
Same process.
same process?
It was essentially the process, yeah, and you would still have to, the commission would still have to take it up under preliminary review and assess the elements of those complaints.
nothing has to be withdrawn.
But you would have the discovery
Presumably complete.
complete. Versus, there's always an issue if you have discovery in one case, how that would translate to a new case, and if there are new allegations, it could get bigger, it could get smaller. So those are, but we have knowledge. If you amend, then at least we have the basis of the complaint. And we're just adding whatever has been discovered in the meantime. That's one. Yeah. Okay, that would be very, very much a layperson's take on it. That could be the case. Okay. Or it could be an additional complaint. Right.
And if it's not consolidated, then you're talking about having the same witnesses, the same facts, and everything decided by a completely different set of the commission.
And possibly all discovery all over again.
This is election and,
It moves on.
and cases can go on, so.
You're also thinking, very quickly, you're setting a precedent that says expect a lot more complaints. Because anytime somebody finds something that was 138 versus 118, you complain. So it's.
I understand your argument. The problem is before.
Right.
Okay.
We're not taking any more arguments in council. I hate to cut you off, but we're not advancing the ball here. We're logging it up, so let's just move on.
Mr. Hicks keeps bringing up about the difference in the amounts. If you look at the motion, it says motion to limit the hearing to items contained in the complaint. We know what items are in this complaint. If he should find, before we go to full hearing, that he has new information, but it's within those items, we're saying he can't bring it up, that we pass this motion.
And that's called due process to the respondent,
Right.
who is now facing a quasi-criminal.
Right? He's entitled to know what he's being charged with, basically.
You're not entitled to show up with surprises.
Right? So
Okay.
you're accused of something, you are entitled to know specifically what you're accused of. With that complaint. From that complaint.
Absolutely.
That doesn't mean that if things come up, you can end or file new or whatever. But
And that's not, this is the law. This is how this commission functions, that's how the law.
that's why I looked to Mr. Richter about the history of the commission, how it's functioned, and Mr. Richter can weigh in, any other insight at this point?
I mean, I don't know if this case is any more complex than any other case the commission has ever had. There are campaign finance allegations and there's, this is established or not. And so I don't see this as being any more complex than any other matter the commission has handled. And, there are, the facts will be brought forth, to me at least. The complaint says what it says, does allege that there are violations of, 13B and D about keeping account of all contributions and expenditures. That's those receipts are for elements of the base elements of the complaint. There's other information that might be beneficial to the commission to help it make a decision. I see those as being something that could be submitted to the commission as establishing, whether it's a violation. That's the way I do this when it comes forward. I don't think I'm wrong, or I don't think that I'm stepping on somebody's due process in terms of how this goes forward. But the allegations that have been presented is that there have been problems, let's put it that way, with campaign finance reporting. And if we get evidence that establishes that, and we make a decision that says that's the case. If there is not sufficient evidence to go beyond what is alleged in the complaint, then we find no violation based on what evidence is presented. That's my view of how this thing should go forward. And so I guess I look at it as we're limiting what's in the complaint. What's in the complaint? You're offering federal account for media expenditures on campaign finance payments in violation of 517.13B and intending to. That's what you have before.
Not specific amount, not specific invoices.
I mean, there are specific amounts included in certain elements in here, yes. But to me, that's what the commission is assessing. And I appreciate what Mr. Fry says about belief as opposed to personal knowledge, et cetera, saying I believe Mr. Freeman will be a favorable account. But with all of the other elements involved in this complaint, research of the records, et cetera, forward, we have certain elements of the complaint brought to us in terms of here are media amounts that are out there that supposedly have been established for this campaign. And we're only supposedly so many expenditures made. There's a discrepancy, and that discrepancy be established in the evidence that's presented to the commission. Why not?
There's also, there's other, slightly different allocation. Because there were two.
I appreciate that. We're only talking about that, but that's what I was talking.
So I guess, now there's a noticeable lack of conversation. That last issue I raised about if additional information should come into Mr. Hicks's personage, if you will, that has a direct nexus to his initial and original items. We're saying by this motion, he's limited to bringing that information up, but he has an avenue to file a new complaint. Correct. On that new information. Do we all agree with that?
I would agree with that, although if I were sitting in Mr. Bry's chair, and again, I don't want to for Mr. Bry, if new allegations were brought forth, I'm sure there will be a motion to dismiss based on res judicata. And if you knew or should have known this, you should have brought it the first time, and you did not. And therefore, you're precluded from bringing it before this commission.
And that might be the eventual outcome, but Mr. Hicks still has a right to pursue a new allegation.
Anybody can file a complaint.
And I would think, Mr. Co-Chair, we've exhausted this, and I think it's time for the commission to make a decision on Mr. Bry's motion.
Is there a motion? Because I thought we were going through. Right, there's no motion. We're only gonna do-
I did.
Right now, there's nothing.
I don't think yes, definitely. Yeah, I think motion.
We vote on the motion to dismiss for lack of further knowledge.
So the motion that Mr. Norman made was withdrawn, which means a new motion is in order. And I would make that new motion, and I would make the motion to limit the hearing to items contained in the complaint.
Is there a second?
I just want to clarify because then there are actually two complaints. Am I correct?
There are two complaints.
That have been consolidated.
Consolidated into one document.
Okay, yes. If that is the motion, but for those, Mr. Norman, put up both of those complaints as consolidated, I would second the motion.
Roll call, please.
Ms. Cunningham,
No.
Ms. Tavares,
No.
Ms. Kaufman,
No.
Mr. Norman,
Yes.
Ms. Brower,
Yes.
Chair Beatty. Yeah. Vice Chair Beatty. That motion does not pass, and it's tied 3-3. 3-3. Move on. It has not been approved, so therefore historically that's what the commission does.
We proceed by requested. I have a question.
Okay.
So that's what I figured.
Is there coming?
Meeting, so much more we just set up in the gray, and I didn't get a chance to. Report him.
I was never trying to, I got here.
I'm not talking about.
No, I don't think so. Just wonder. Yeah, okay.
Sure.
I got it.
You said you need another one.
And there's one right here as well, right?
Okay.
Right. I don't do it, you know.
Or is it paranoid?
I'm
My battery's fine, but I get paranoid that someone's gonna go to zero and your cells.
I don't see them.
I have no idea, there's a teaching plan, but I can't guess what there is. I don't agree with most of that, and I don't think it's not. I don't understand what it's.
Just so you're clear, report.
You know, I barely.
Broad shoulder.
Who's off the gym for you?
Dennis and Catherine.
Hey, Chris, how you doing?
Yeah.
Too long right now.
You're ready, right?
No, it is September. I'll send you a book also for signature.
Thank you.
And
That's it. Twice a month. Yeah.
I'm gonna be declining the chair, and so it's gonna go to me.
Oh, no, it's not. No, it's not, you know.
Oh, it will be back. Listen, wait, how can you not say that? All the leadership that comes out of Allen County now.
There's a lot of it.
Yeah.
And
All the leadership that comes out of Allen.
listen,
That's your county, right?
this is me. This is me, okay? Actually, I live in Albany.
Oh, okay, I'm
Yeah.
sorry. I haven't taken Ohio geography.
And we're close.
Right,
Oh, yeah, we're kissing cousins.
right, I know.
Yeah.
So Lima, is Lima in Oakland or Allen?
Allen, yeah.
Okay, all right. Sure.
Yeah. No, and actually,
It's too long.
I still have a minute to run into the bottle of water.
Go ahead.
very be quick, run. No.
I just hope the correct.
We're not gonna be talking that much when we get back here, so I hope that's not that.
Yeah, more motions.
Yeah, no, mine is in Allentown.
Looks so good.
No, it's not.
People did it, I'm like, people did that. That was all story. I'm just ready.
They talk about, I want to turn the channel on maybe two of us. It's up to you. I know, I'm happy now. Okay, thank you. What do you think? I think you can make all this stuff. But there is, I usually love it, it's time we get that. Yeah. I'm sorry, I don't appreciate your insight.
I've been retired.
My wife is well, she does business stuff, she has never seen it before. But maybe shop at all.
Yeah.
She just got some documents.
It's crazy.
Oh. Okay.
Well, my husband doesn't do it. So He does not want to turn on and shoot out. That's all that.
I did not. I apologize, you can give us.
I don't know.
Oh,
And I really see it.
She did not, but this morning, for whatever reason.
You know, I don't know.
So, just as soon as, yeah, no, as soon as very shocked. There.
Phil's coming. And this is. Witnesses like, almost like a spirit, it's like deja vu.
My dad, on the opposite side, the very sort of actual, and his father was president last week. So, my grandfather, his father. Oh, he was like, it's over Illinois, so I could test. But my dad was on one side of the fence, and my grandfather was the
Oh,
strong.
wow. So much, you learned it from both.
So I'm right here in the middle.
I do this, okay.
And,
And I was feeling. Oh, so when are you?
We're sympathetic.
Okay. It's pretty, that's actually. I don't know what she told me. Right. I say a lot. It could be, it just seems that.
So.
You don't know what you know. Yeah. Yeah, you need mom when you know the most, you can want to share the voice, the books or whatever. Yeah. And sometimes. Yeah. At this point, you're on the computer. I mean, you have to take a test that you know, so that they know that you actually, went through the process. Yeah. I mean, then it's a lot, and like you 30 minutes, I'll teach them. And then like you, and then that's the work.
No.
I don't want to see you for that.
Thank you.
Yeah, we did all that. Oh, excellent. First grader.
Should wrap them all in.
So I drink my water. Nah, like that.
Aggravation, I like it, that doesn't end up make it, you know. Awesome. She's on the ball, like she is a researcher and. Let's advertise, you know, that she,
I can do that.
She was down by the tournament.
Yeah. Never should have. That's that way, like, instead of that, yeah, the other day. And then, I was looking up, exactly. Yeah. The most there. Their energy that is something. Yeah.
She's on a criminal. I haven't struggled with you want to discuss to the person deposit. $150. There's 12 parties. Like $22,000. I had the same reaction. I'm like, what? Especially by being pre-engaged.
So they said,
Right.
my mom's there.
Years.
They know just what that is.
Since we, of course, see it here.
I like.
You don't have to control the doctors. Stress.
He's been so, I think, sad and controlled with the, you know, and so he's watched everything, you know, it's funny because real places. But I said, yeah. And I was born there, and then it was, did you see that? Sorry. Yes, and you probably, so it's kind of like morality, you know, it's like, right.
Okay, let's go, get started, go back on the, record. So the next is the, Anne Freeman motion for wash.
Mr. Chairman, members of the commission, before we proceed to that, I clarification as to the 3-3 vote. I understand denied the motion to limit. The question I have is whether that if it is still limited by virtue of our constitutional rights to have the facts set forth, as Mr. Thomas pointed out, whether at least 3 members of the commission believe that it will be appropriate for Mr. Hicks to present and for my client to be potentially clearly liable for failing to report expenses that were never identified in either of the complaints. I think that it's plain. I think, well, obviously, it means normal notice that the face of the complaint is limited to saying you failed to report an expense, and this is the expense that you failed to report. Obviously, there are other matters about this expense that you failed to report, but the Constitution cannot, and statutorily, you are prohibited from allowing a hearing in which other expenses that were never identified in any are then putting my client in a potential criminal jeopardy without any adequate opportunity to prepare for that. I understand the commission's concern, well, this will take too long, and there might be other complaints, you might be back in the same place. That is not a justification to deny my client his right to write what it is that he is alleged not to have properly reported. And just because you cite a statute doesn't mean that you are liable to defend every possible way in which maybe you failed to report something else. And I would respectfully suggest that there be some clarification as to whether or not we at least have our constitutional rights based upon please, or whether in fact 3 members of the commission the 8 facts that were never pled, that he can argue at the hearing as a basis to maybe have my client refer for prosecution. I'm going to come on it because we do have some real interest in knowing what the heck we're going to be trying to defend and to.
All I can tell you is there was a motion, it wasn't granted, and if I were in your shoes, I would be prepared to object at the hearing. I don't know what else I can say.
Your objection today is not.
I would request if there's any of the minority or excuse me, any of the folks voted against it, if so inclined, that there be no motion to reconsider.
There being none.
Mr. Chairman, the commission, I'm also here on behalf of Pam Freeman, the wife of Alan Freeman, who is here to testify not about either of the items specified in the complaint, but about a direct mails out chase, according to Mr. 1525, 2021 email. It's not about 6 invoices in the first complaint. There's nothing to do with help in the second complaint. Yes, so even in terms of relevancy, it should be excluded under Article 2 and rather this commission under 3570-11 it's fully relevant evidence. Even if she were subpoenaed to give relevant evidence, she can't necessarily require just against her husband, who is being charged with a crime. Is therefore something that you seek a criminal person. And that's evidence total 6 as well as revised code 2370 to D gives thousands of rights, absent consent or waiver, and she's not consenting and she's not waiving the spell of privilege, not to have to testify against their spouse. He is in her for irrelevant testimony and to testify against her husband, which is improper and therefore is overly burdensome and frankly so is the harassment shouldn't be issued under the commission's rules. So the only purpose for which she is defeated are purposes for which she has testify. We believe that the motion to quash should be given.
Looking.
It's looking at, yes.
But no question. So it's clear that Pam Freeman had communications with Megan that was capturing imagery that was used in various matters with Megan Fitzmartin. Megan Fitzmartin was the person involved with the approval of media pieces. That's also in the discovery. I wish to question Pam Freeman on her communications with Megan. To the degree that implicates her husband or something, I would assume she could assert her right against self-determination or spousal privilege. But it's clear, I provided in my response that the wife of Alan Freeman was having direct contact with Megan Fitzmartin, which is a key figure in transferring media pieces to Megan Fitzmartin with Alan Freeman. It's fair game to ask her about those communications with Megan. I'm not planning to ask her about any communication whatsoever with her spouse, Alan Freeman.
I think I reserved some of my 5 minutes. Nothing in the rules require an immediate communication with his spouse.
They reserving time. If we're going to follow the rules, you have to declare your verdict.
We want to give you way on this. Move forward. Thank you.
None of the rules that say that it's, the rule against requiring a spouse to testify against the other spouse isn't limited to communications with that spouse. In the governor's rule 601. There is also a separate, privilege against the communication regarding communication. So that there are separate requirements. She has the right not to testify at all. It is her husband, and obviously if she's not testifying with her husband, it's not relevant. And that Mr. Hicks wouldn't have any reason to call it.
Any discussion? Question? Question? Yes, but there's anything director.
I look at it as spousal privilege, and that's why I recommend sustaining the motion. I think it's regardless of the elements of why the testimony was sought out of the spouse, an ability to not testify. That's where I'm coming from.
I move that we grant the motion to quash.
Roll call.
Sorry.
Commissioner Navarro.
No.
Commissioner Call.
Yes.
Commissioner Marlon.
Yes.
Commissioner Warner.
Yes.
Commissioner Cummings.
Yes.
Yes.
Thank you. Sorry, I was slowly in my writing. Okay, so,
Count, please.
oh, I'm sorry, that would help. That motion passed 6-1.
5-1. That was
5-1. I know we got-
seven.
Just gonna. The next motion of consideration would be the motion from Jane, who is beginning to quash the subpoena that has been issued to her.
Get,
No.
oh, that's it. Oh. Good afternoon. Something. Introduce yourself, please. Good afternoon.
Absolutely. The Mueller State. Renata and here on behalf of Jane Campbell. Or the story.
Right, please.
Rachel Mays.
Okay.
Before I get started on the motion, would I be able to reserve any 5 minutes that I don't utilize during the presentation? As for our
Good listener.
yes, thank you very much.
How much would you like to reserve?
Or to have a legal grant.
That is appreciated as well, so thank you. You're here on behalf of Ron, Jane Timpton, who was served with a subpoena to appear on October 7th at the request of Mr. Hicks. We filed a motion to quash, which I know you've already read, and you saw that we filed because Ms. Timpkin has no personal knowledge of the matter set forth in either of Mr. Hicks' affidavits. She doesn't know anything about Mr. Freeman's media lies or anything about Luke household activity. Ms. Timpkin also has no personal knowledge of the alleged violations of campaign finance law that Mr. Hicks accuses Mr. Freeman of committing, and those are at the heart of the matter before the commission. Ms. Timpkin also had no personal knowledge of the day-to-day field operations of junior campaign staffers, such as Mr. Mulsini, who is referenced in one of the complaints filed by Mr. Hicks. In short, Ms. Timpkin, who was chair of the party, has responsibilities at that time that were outward facing. Someone else, the executive director of the Ohio Republican Party, was responsible for the day-to-day field operations. So if you've read our motion, you've also seen that we moved to quash because during a conversation with Mr. Hicks, he indicated that he was also going to subpoena Rob Secar, former executive director of the Ohio Republican Party, as a witness on October 7th. And since Mr. Secar does have personal knowledge of the matters that I just referenced, it was indicated that if you are subpoenaing Mr. Secar, then why do you still need Jane Timpkin to come in and answer the same questions in duplicative? And Mr. Hicks did not respond as to why he needed Ms. Timpkin if he was bringing Mr. Secar. Again, Ms. Timpkin has no personal knowledge of those matters, and Mr. Secar does, and is available to testify on October 7th. I also wanted to reference a couple of things that were in response to the motion to quash. One of them was Mr. Hicks cites to a radio interview that Timpkin had in Claremont County, and he tried to draw the connection because she had a radio interview in Claremont County. She seems to know everything about Mr. Freeman's activity and his campaign, and that's just not the case. What she did in that radio interview is something that the chair of the party typically does. That's an outward activity. She came in at the invitation. She spoke regarding a different candidate during that presentation or that interview. And that did not mean that she has personal knowledge of what was going on with Mr. Freeman's campaign, all the people working on it, who was supervising Mr. Nancy, or any knowledge of the tax holder. Because Mr. Hicks was unable to determine or identify for us what he needed in an affidavit when we had proposed an affidavit for Jane Timpkin rather than her coming in to testify before we knew he was going to call Rob Secar. It seems that there's no real valid reason for her to come in other than he wanted her to come in harass her. The purpose of the subpoena is harassment, particularly knowing that someone else testified to the things identified when she cannot and does not have personal knowledge. If he really wants testimony that goes to the heart of what he believes the allegations are, then we ask the motion to quash Jane Timpkin's subpoena granted. Those are going to come if I may have it.
A little over.
All right, so I wanted to reserve time like she did, that's to say. So Jane, and the reason why it's significant is because the case involves specifically how resources in the ORP and how resources that should probably be in kind contribution to the ORP that no longer, how they should be reported vis-a-vis the candidate Alan Freeman. So there were resources from Constant Content supervising the ORP resources that all come in. Tommy Roll, RJ Mancini, they're all interconnected. It represented that the chair of the Republican Party had no idea who was, I guess, I don't want to get, has no personal knowledge of what the management structure was of ORP resources or how resources that were not being reported on any finance reports were being, the existence of them. And I guess what she's saying is Rob Secord does have knowledge of that, and but the chair of the party did not acknowledge that. I would like to have her, Ms. Timpkin, make those assertions. This is the first time somebody laid out in the call-out video that they went and answered the question, what is she prepared to represent? Okay, I was approached about her potentially having an affidavit in this case. I would be glad to see an affidavit from the applicant stating that she didn't have any personal knowledge. And that would help to clear up the issues, but I don't know that just, I think you probably should go beyond. That's what the original intent of the call was. So I believe that I went and have made sure that the assertions that Jane Kemp doesn't know how those should have been reported, because remember, part of the resources were reported by the ORP and should have probably been accredited as an in-kind, I think, by Alan Freeman. But what I'm hearing is she had no personal knowledge of that, but she did have personal knowledge of what's the policy and what was supposed to happen in these cases and where were these resources supposed to be reported, and was there information in candidates to facilitate the reporting? Because what I understand is that the ORP, I'm getting a little ahead of my headlights. The ORP provides information to the candidates for being able to properly report their in-kind contributions. Those are all germane. I think it gets down ultimately to what should have been reported on Alan Freeman's campaign finance report, the cost for RJC and the supervisor resources that were involved. But I would have loved to have Ms. Timken actually put most of what you just said in the affidavit, and if she would be prepared to put that in an assigned sworn affidavit, what you just said, I would be fine with the most of it being fought. But otherwise, I think I want to be able to have her and clear those things as to these resources and where they were reported, and what was the policy of the ORP in terms of where they were reported, and what does she think for the policy of the ORP should have been being reported by the candidate. But I'd love to have an affidavit that says that, and then I'd be glad to go along with it. I have my time.
No. Yeah.
I'm done.
Well. Yeah, but that's smart.
Jump right on it.
No, but I think the way have the response, and at that time, let us get it, if there's any commissioners that have a question or not. We normally have to proceed, the person that brings the motion, if you respond, the rebuttal, and that's what we get.
Okay.
Okay, go ahead.
I would just indicate that Mr. Hicks suggested that Ms. Timken has no knowledge of the management structure. That's not what we're saying here today. What we're saying is that she did not have day-to-day knowledge of the people who are on the ORP staff as junior campaign staffers. I should say on the ORP payroll as junior campaign staffers, and how they were deployed at any time. That is not something that she was responsible for. There were other people who handled that, and Mr. Seacard does have personal knowledge of that. So I just wanted to clarify that is what I was trying to say. Not that she doesn't have any knowledge whatsoever, but regarding what he's asking here for these specific, only two people have been mentioned, two specific junior campaign staff. She was not involved in the day-to-day field operations. We did not have knowledge of that. Also, one of these people with household or purchase allegations was paid for JP&L Associates, which again, that's something that Ms. Timken does not have knowledge of. That's probably should be addressed to JP&L. Ms. Timken doesn't know what Mr. Freeman did or did not actually report, but as Mr. Hicks indicated, the ORP did make their appropriate disclosures, and those are in the public record as to how those resources were made behind to the HRC.
That's your time.
Let's let the commissioners ask a question. Right now, if we have any questions. Sorry.
My comment would be is he was asking for council saying there are presentations on top of it seems to me that you've got enough information for this council. I would move that we quash the subpoena.
I have a question regarding the policy of the ORP and in-kind. That seems to be where Mr. Hicks has some concerns about how in-kind services by the ORP is recorded, or what the policy is, so that the campaign or the executive director or the junior staff members know how it's supposed to be monitored. on behalf of the ORP? Does she, I mean, does she have that kind of knowledge?
So I can't speak to a policy because I don't know exactly what policy anybody is referring to. I can tell you that Mr. Secar can speak to the practices of the people that are on the payroll, and that their salaries are made as an in-kind contribution to HRCC.
And I'm sorry, what is the status of Mr. Secar, being deposed or being affidavit or anything like that? I assume you don't represent him, but I'm also, now I am opening up the door to Mr. Nixon, I'm sure he knows the answer.
I can respond. We will be representing Mr. Secar. My understanding that a subpoena has been issued, but I don't know that it's been served. That I don't know, but I believe that it has been.
There should be, you're the one representing. him.
Well, I believe he's prepared to be here, but as far as I know, as of yet, I have not been served with a subpoena.
And I'll put in there, I have prepared the subpoena, I have sent it to the sheriff's office, we have not gotten it back at this point. Confirmation that there has been served, but there has been a subpoena prepared and circulated.
And Mr. Hicks, would he have any other opportunity for discovery? For anything? No.
I would like to just very quickly say two things that she said. She said there were two campaign staffers, which would be RJ Mancini and Luke Castleter. RJ Mancini was reported by the ORP, but not reported in time. Luke Castleter was not reported anywhere. He wasn't reported by the ORP, he wasn't reported at the expense of the Freeman. I think she's raising the points that are the relevant questions for Ms. Timken about where should these resources, per your view, and the policy of the ORP, have been reported. It gets at the point of should they have been on Alan Freeman's expense report and how so or not. The other thing she said was that Rob Secor is aware of the practices. He's not aware of the policy. That's what she just said. So, and my questions for Ms. Timken relate to what's the policy? I wouldn't expect a junior person like Rob Secor to be an expert in campaign finance, where by policy these resources should be reported on finance reports. I would expect the party chair Jane Timken to know those answers. That's why she needs to be asked questions specific to where should these resources have been reported. And because they weren't, one of them was reported by the ORP, but other than done by Freeman, one of them was reported by Hank.
Okay, thank you.
I like what you cut on. So, it's not even positive. Good.
So, Mr. Hicks, it's your assumption, I use that word, your assumption, that because Ms. Timken is was chair of the Republican Party board in Ohio
Yeah.
that she must know all this information. You have no other basis other than your assumption. Is that a fair statement?
I think I would, that I believe that the chair of the party is responsible for the policies of the party. So yes, not only do I expect her to know that, I expect her to be the one that's creating those policies and enforcing those policies, whether they be written or unwritten. And that's why it's so important to be able to question her on what was the policy? Where should these people have been reported? And we get to the point, maybe Alan Freeman shouldn't have reported. Maybe he did the right thing by not reporting anything. Maybe Luke Castleter didn't need to be reported by either Alan Freeman or the ORP. But as the chair of the party, she uniquely, unlike Mr. Secor, who might know practice generally what they were doing, she would know, and only she would know, what was the policy, or she would represent that they didn't know. She didn't know what the policy was.
Okay, I think you answered my question. And for the record, I feel that before we take this vote, I have to disclose, and I just discussed this with our executive director, that for 15 years, I represented all the union employees at the Timken Steel Company and the Timken Bearing Company. And in that time, during that time, her husband was the CEO of Timken. And I never met Ms. Timken, and I don't feel that my eventual vote is in any way prejudiced by the fact that I represented the union during those years. But I wanted for the record to disclose that.
Thank you. So,
There is a motion. There is a motion. Sorry. Go ahead.
any comment or recommendation or thought?
Just a comment, before Bill, there's this box there, just a question with respect to getting information on the policy of the ORP on income contributions. Who else would we get it from? If not the chair? Is there someone else that we get it from? What the overall policy is of the party, not a staff member who's paid, but the leadership of the organization. Just like for the Democrat Party, there's a leadership team, and they're the ones that discuss, develop bylaws and policies, etc. So who else would we get that information from?
Council, that's a fair question. If the crux of your argument is that the chairwoman would not have that information, then I assume the next logical step is this is who has this scope of information.
And I'm not going to testify. So I just want to make it clear that we're talking about the policy sort of in the abstract, okay? I don't want to represent that I know what policy you are all referring to necessarily. But I believe that Rob Secar, if there is a policy that has been approved by the leadership of the organization, he was the executive director of the organization and responsible for implementing that policy, that he will be able to testify about that policy. And that's why I called it a practice versus a policy, because I don't know that there is a written policy, and that's what I have we were talking about. I'm just not here prepared to say that the policy you're referring to is X, Y, Z, and here's what it says. But Rob Secar, as the executive director responsible for day-to-day field operations, would understand what you're referring to and would be able to.
Well, and an issue of, and maybe it makes sense to your initial presentation, that you're saying that Timken firmly does not know, or you don't know what Mr. Hicks is talking about, so you can't say she knows or doesn't.
That's correct. And in addition to that, even
Correct
if
is the
she were
latter.
to know any
The
part
latter.
of that, Rob Secar also knows it, and he knows these other things about the day-to-day field operation, which seems to be, at least it was my understanding, based on not only the conversation with him, but the reasons that he asked for the subpoena and his complaint, that what he was looking for was the understanding about those junior staff members.
Yeah,
Does that answer your question, Commissioner? Or does that lead to more questions?
it probably leads to more questions, just knowing how we run campaigns and being part of one campaign. I know when in-kind contributions come into my campaign. And I know that the party makes the decisions of who they're going to provide in-kind services to. And then it's documented. The party knows what their policies and practices are. So I guess, I don't know whether it's C4, I don't know whether it's Timken, but certainly the leadership has documents on how they do X, Y, and Z.
Other comments or questions?
I guess just one question, Mr. Co-Chair. Or I should have directed it to Bill. We do have a subpoena for Mr. Secor.
Yes, it has been prepared and circulated. No, right now, I don't know status of the service and I'm not checked back. I mean, we could request, or we could ask his counsel, who has identified himself as counsel, if they could guarantee that he will appear, since you're here with us now at this point.
It's my understanding he's planning to be here.
As a matter of fact, subservice on his behalf.
That sort of thing.
And to clarify, because you, Mr. Hicks, said that sort of the junior campaign staff, but Mr. Seahart is the executive director.
Not
Not
junior
a
campaign
junior
staff.
campaign staff. So he would have all the knowledge that we are trying to. Yeah, make known.
Yeah, I'm sorry to interrupt, but he is not a tumor campaign.
No, I know.
Absolutely, yeah.
Correct. So I've just heard that term banter, then I just want to make sure that we are all clear that he is the executive director and that he has.
He is former executive director.
Okay.
We should just clarify that, but he was the executive director at the time.
He has all the knowledge that we are trying to.
So I want to clarify what I said. I said a junior person, when I referred to him, it's a junior campaign staffers or Luke Council or RJ, and I want to point out something that's very important that's out here. Is that the member Luke Householder who's directly in the complaint was not shown anywhere, And based on Mr. Steve Flores' statements, there could be a difference in what was the actual policy and what was actually happening in the field. Because Steve, RJ Mancini was an ORP staffer and reported by the ORP, a question about being time. Luke Householder was being supervised, but wasn't being reported anywhere by anybody. And one of the things behind this is, behind that particular line of question, where only the chair would know the actual policy, because potentially there was a breakdown in the field of what was actually happening versus what was the actual policy. The policy is important, most important, because that would reflect on where should these resources have been reported on a campaign finance report, and to what degree should they have been reported on Alan Freeman's campaign finance report. And I don't think anybody other than James Timken, or if you can name another person, from a policy standpoint, could reflect on what was the actual policy of the ORB.
Bring in my motion to quash.
Second.
Call the roll. Executive Director.
I can call the roll this time.
Comment on the motion.
After hearing the argument, I sustain the motion to quash. Since, particularly since it's been represented that Mr. Dees are present, and be able to testify on all the elements that have been raised here in terms of policy elements, et cetera. And so I would be inclined to grant the motion is to quash. Mr. Brown,
Yes.
Ms. Kaufman, Ms. Tavares,
Yes.
Mr. Norman,
Yes.
Ms. Cunningham,
Yes.
Mr. Beatty. Yes. That motion passes 6-0.
So I know you said to accept service. Did you receive the copy of the subpoena or you need it?
I have not received.
Chris, I think you've got information stated, motion. Can you forward that to her, please? Thank you, sir.
Absolutely.
Thank you.
Last item at this point, Mr. Vice Chairman, members of the commission, motion to quash concerning Jean Schmidt and her presence. And hearing Mr. O'Brien is presented with that motion.
You may proceed.
Thank you, Mr. Beatty. The complaint that was filed against Alan Freeman is in many respects similar, if not identical, to the complaint that was filed against Jean Schmidt. Jean Schmidt is probably in parlance and at least an argument presented by Mr. Hicks previously and even here today, a co-defendant of receiving in-kind contributions from the Republican Party that were not reported, and also receiving the same media production company and media buying company involved in at least the profit that Mr. Hicks made to Mr. Richter when the scope of these hearings were being scheduled. It related to her knowledge or participation in filming of ads for both Mr. Freeman and Mr. Schmidt, as well as both of them purportedly receiving the benefit of Luke Householder having been down there and alleged war on both their campaigns. Quite clearly, he can't issue a subpoena for her in the hearing on October 7th and have her testify. She's functionally, as I say, a co-defendant. She's functionally charged with the same thing, failed to report and the in-kind as well as other, what are alleged to be corporate contributions, which we gave that were not quite clear who the corporation is. But in any event, I think it's absolutely clear under no circumstances that he's either her and have her testify and appear at the hearing for Mr. Freeman. And they really had nothing additional to add. I think she's quite clearly in a different situation than for Simeon on the previous case. Who a witness. She is a defendant, functional defendant, in a quasi-criminal proceeding, which the commission has the ability at the end of the day to refer for criminal prosecution. So there's no way that she can be subpoenaed. If we have two people charged with armed robbery as an example, and they have separate trials, separate dates, you can't subpoena the other person who's charged along with the two people that robbed the store to testify in the first. I think Mr. Hicks kind of takes a position. Yes, I can. Yes, I can force them to take the stand. Yes, I can start asking them questions. And if they want to take a Fifth Amendment, they can do that. Well, that ain't how it works. You just can't compel their attendance. You can't compel them to take a witness chair. And you can't even ask that first question without their consent. So having said that, I'll be happy to answer any questions that members of the commission have.
Any comments, questions?
Okay, thank you for your attention.
The specific subject matter that we can question you Schmidt over is the actual filming of the commercials. Where she was present, other candidates were present, they were actually filmed at locations that were her family locations, the relatives of hers. Also, the invoices in the original affidavit, several of them were joint invoices. So between her campaign and Alan Freeman's campaign. So I think I have the right to question. I didn't make allegations that her complaint of the filming of commercials, some of those the specific invoices. And I think I have the right to verify these are the witness to confirm that she was present, Freeman was present, who was present at these filming that took place at these commercials. Megan Fitzmartin was present. The locations of those commercials. And then the invoices that she acknowledged that the invoices, which ostensibly she has been based on her campaign filing, that those invoices were, those joint invoices were invoices that tied to her partly to her campaign. So I think there's a set of information that only she has, that only she can confirm that, for example, if I play a commercial where you president filming this commercial was Alan Freeman present for, that sort of thing, that only she can do. She's inextricably tied to this because there's certain facts of the case I would make against Alan Freeman where she was directly present at when those things took place. So I think the motion should be denied. And I'm glad to limit my questioning of her to just the facts of who was present at the filming of these commercials. Were these invoices that were his, did you pay these, did you acknowledge he was valid invoices within your campaign? I don't think those particular questions have criminal culpability on the part of Gene Schmidt, but they're instrumental to the verification of those, the facts of the case.
Any more questions? Mr. O'Brien, you have a response or?
I really don't. I think the issue is very clear and would ask the commission to quash the subpoena for her for the review.
Would she be willing to have an affidavit confirming that these were found at her location?
Comment, any further comments, questions? Is there a motion?
Move to grant motion to question.
Is there a second?
Second.
Call the roll.
Before we vote, I'd just like to hear from the legal perspective here from our sitting attorneys here and from the executive director. Mr. O'Brien proffered that it's illegal. It would be illegal to have her come in and testify since she is a co-defendant.
Functional co-defendant, correct?
You can't, once you open the door, she can't close the door. Once she starts testifying, all bets are off and they get to ask whatever questions they want. And so they have the right to say, I'm not going to testify.
There's a complaint, I think, against her here, which we heard, and there was a great debate about whether or not we were going to dismiss it and not absolutely pending. And so it's not just necessarily what's in that complaint, but as we talked about a lot today, if she testifies and evidence comes up that is sufficient to be instigated. If I would have another complaint, not necessarily one pending before her, that would also be barred, which is why people have a right, a constitutional right against self-incrimination. So that's legal or not, illegal or not legal, but I view it as sort of a constitutional right. So when she has been charged in a quasi criminal proceeding, in one case, I don't think they can force her to be with another case, in which she would incriminate herself. Independent case, but also for the filing of possible other criminal proceeding against her. So that's sort of, it's not really about the intent of, how the that testimony. It's really about her constitutional right, from my perspective.
You don't need to hear more from me, they said it all. Okay.
And I have a question though. So Commissioner Norman said, once they're there, even if someone says, I'm not going to ask them that, if they do, it's, no.
Once you consent to testify, you can't pull it back.
Right.
Ms. Kaufman?
Make a motion.
Motion to quash, to grant the motion to quash.
Yes.
Mr. Brommer?
Yes.
Ms. Tavar?
Yeah.
Mr. Norman?
Yes.
Ms. Cunningham?
Yes.
Vice Chair, Bailey?
Yes.
I almost changed your name. Sorry. That motion passes 6-0.
Did he become a lady?
Yeah. what?
He's,
Thank you, Mr. Commissioner. Can I ask what, the status of other subpoenas, because I'm concerned with October 7th that some of these subpoenas haven't been served.
Yeah, but.
I can check on them either late today or
Are
tomorrow.
already agreed to receive an email service, like Adam Bird already agreed, so why didn't we get an email service?
I didn't know anybody else had agreed to email service. That was never presented.
Specifically, Adam Bird got email service.
I would respectfully suggest that this is found in the agenda.
RJ Mancini did. I never served that.
And it can be communicated directly to the council without any.
Well, I'm just concerned that there's a lot of witnesses on this list that can impair my ability to put a case on. When for reasons I can't explain, there was significant delays in the subpoenas even getting issued to people.
Well, I would say that that's not an issue. It's currently on our agenda. I suppose you need to work through the executive director. You got it. Sure.
Those are procedural issues.
Should I go ahead and get Mike?
Yeah.
Oh,
He's probably sleeping.
You ready to give up the gavel?
I apologize for all the delays for you, but we'll deal with your case right up front. Well, as soon as the chair comes back, come on up.
Okay.
What I will say is, well, I'll wait till the chair comes back anyway. And you can whatever.
Take a nap. Right, I know.
Welcome back.
Hey.
Thanks.
Take him to the top. To the top.
Welcome back, Mr. Chair.
Oh, it's good to be.
This gentleman was not originally on our list, so unfortunately he just got to sit through a couple hours.
Hopefully you learn a lot.
And I said, I was waiting until you. Now that we're back on the record. Mr. Kirk, you've been referred, by the Board of Election, not by the Board of Election, excuse me, by the Secretary of State's office. I'm just double checking what the specific allegations are.
I think essentially they're going to file annual reports.
wasn't sure whether, we've gotten, see, failure to file a request an addendum to the 2016 pre-general, 2016 post-general, 2017 annual report, and failure to file the 19 and 20 annual report. When I looked at the secretary's database yesterday, where they have it available as to what reports have been filed, none of those reports have been filed. And so right at the moment, my recommendation is to find that there's a violation of the statute and impose a fine of $25 per day until all of those reports are filed. That's my recommendation. Currently, we will, give you an opportunity to be sworn and have a statement, but at least according to the secretary's website, nothing has been filed. When I checked it yesterday. So anyway, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Okay, thank you, please.
Standing sit, my choice.
Yeah, your choice.
Okay. So I'm actually, I guess, happy to be here. The reason we kind of find ourselves, or I find myself in this scenario is I chose to be the treasurer of my campaign. And in the process of that, as I'm sure some of you that run campaigns know, things get bogged down and basically I had a contribution fall through the cracks where I could not make it back to who gave me the contribution. It's like a $25. Not a significant, I'm not gonna say, but the material amount of money, but not crazy. End of the day, I could not file the reports that balance out because I could not document that contribution. I went back and forth with the Secretary of State's office over and over again. I also made the mistake of making with my local credit union. So like my Chase account, or if I did a check or write a check or whatever, I just click on that little button and it shows me the image. Credit union doesn't work like that in Yellow Springs, Ohio. If you want to try to find a check and you didn't record, which I made the mistake of not doing, they literally have to go back through and dig through file cabinets full of like print, copies of checks. And we did that, and we looked and looked, and I still could not find a record of the check that that I didn't already have. And that's my fault, and I take responsibility for that. But I have not been able to file a report that matches what we want me to say to essentially close out the account. And that's kind of the situation I found myself in. And this is, again, this has been years and years and years in the making. I haven't touched any of this, probably since like 2017 or 20, a long time. And I've since, like everybody else, get to move on with your life. And, I would like to put this, my past behind me and just figure out what we need to do to come to a sufficient resolution where everybody can be happy and moving forward.
What's the balance in the account today?
Oh, zero. It only had a few dollars in it, and then the bank, when you aren't having regular deposits and things, you get that annual monthly checking amount that comes out. It wrote out years ago, they closed the account. So that's where we're at.
When you can terminate the committee?
I'm willing to terminate the committee, yes.
Are you in public office?
I am not.
Do you plan to be
No.
running for public office?
It's kind of in public offices I'm on, I serve on our local planning commission. That's the extent of all with, local public office.
Not elected officials.
That's correct. Yes.
Go ahead, Chair.
Yes, questions for him. Mr. Richard, do you have any other pending and open cases from him, or is this a first?
This is his first referral. And I'm currently kind of looking up to see what his last line was. But no, this is his first referral. Now, the last filing, I don't know if you're aware, but the last filing of the secretaries, and I'm looking at their very basic search engine, shows you with a balance on hand of $300.22.
That's not accurate.
Well, okay, this is from
Yeah.
$300.20 as of the filing of the 2017 annual report, which was reflected as being made on March 15th of 2018. And so, that's what the secretary's office showed. And I'm sure that's what the base of the addendum request was, is that there was, as he indicated, a check you couldn't find, et cetera. You know, and so that's his status with the Secretary of State's office. And you are saying then that at the time, there was $300.22. Do you know how fast that money disappeared shortly after that? Or, I mean, is that?
I don't think
bring
there
back
was
any
that
kind of-
much money in there, not to my recollection.
Mr. Chairman, can I ask a question?
Yes, of course.
What are your credit union's fees on the annual basis for holding the account?
I'll be honest, I don't recall offhand.
It's 17, quite a few years.
Well, and at that point, you know, it had been enacted at that point for well over a year. It had been active since November of 2015. Is that right? Or maybe 2016.
Well,
Yeah,
the prior filing to that was a 2016 Post General report, which there's another reason why the Secretary wanted an addendum file that showed a negative balance. It didn't have a negative balance in your campaign finance.
Well, see, but again, that was because I didn't have we were off with that check or whatever. I don't know. That's a,
So I'm confused. In 2016, they had a negative balance, and in 2017, they had a positive balance of $300.22.
Right.
According to the-
Right, all I'm looking at is kind of the cover sheet.
Yeah, okay.
Is the electronic equivalent of the cover sheet, so I don't know any details behind it, but yeah, it went from, you know, and here's the pre-general showed a balance of $1,900, 1997, the post-general in 2016 pre-general, which would make sense, sending money to the campaign, et cetera. But the post-general showed a negative, and then the 2017 annual reflected $300.
Is that the most recent information you have? The 2017 journal that was filed?
The 2017 annual that was filed in March of 2018, correct. That is the last, you know, I've gone over the last 3 reports that are reflected here as being filed.
Mr. Chairman, can I ask another question?
Yes, sir.
So from 2017, you haven't run for office?
no, I learned my lesson.
And, well, and again, and you do not anticipate running again in the future?
No, you're welcome to ban me from it.
No constitutional violation.
Well, I will interject. Going back to my days in law school, when one of my classmates knew I was working with the Elections Commission, I told them at the time, if you ever hear of me trying to run for elective office, you have every right to come up and slap me upside the head and say, what am I doing? So I fully well understand Mr. Kurtz. You know, Mr. Chair, members of the commission, this is the kind of case where, you know, we could continue, say, you know, do the best you can, et cetera, and can kick it down the road, or we come to a situation where, you know, especially based on Mr. Kirk's sworn statement to the commission as we go through this process here, you know, I could change my recommendation from what it was to recommend the commission find that there's a violation of the statute because those reports were not filed. But, you know, as a result of that finding, impose a fine, which at this point I'd recommend $100, but then declare the committee terminated based on the circumstances that have been presented to us in the statement.
Questions by the commission as to the proposed recommendation of the executive director? I'm going to move that we follow the executive director's recommendation. All right, do we have a second?
Second.
That motion, then, as I understand, would be to find a violation, impose a fine of $100 and declare the committee terminated.
That is correct, Mr. Chair.
Any further discussion on the motion? If not, all in favor, signify by saying aye.
Aye.
Opposed, same sign. Motion carries.
Thank you.
Thank you,
Appreciate
Mr.
your
Chair.
time today.
If you would, just make sure Chris has current address information before you leave.
Sure, I'll just write, can I write you a check now?
Never turn down check. Taking a check here.
I will add, when, even if you write a check now, when I send that disposition letter out, it will reflect, the commission on those one, or fine, it's already paid. And, just so you've got something for your record showing you've already paid it.
Yeah. Okay, are we ready to go back then to the group consideration?
Now we can go back to the group considerations, Mr. Chair.
Okay, first case is 2021R-230. Recommendation that they be continued, Dr. 28, 2021 on request of respondent.
You can do
So
that
be
on
it.
your own, Mr. Chair.
So be it. Case 2021S-025, set the matter for hearing. Mr. Rick?
Yeah, this is, if you looked at the ICW that I circulated for this case, it's the second referral we've had on the matter. I talked to an attorney for the treasurer, who is the ex-husband of the inmate, and discussed with him the general circumstances. And he and I agreed that the best approach at this point would be to set the matter for hearing. In the intervening period, I will send a subpoena out to the campaign, what did they refer to? The campaign consultant, one of the assertions by the complainant, who is subsequently supposedly moved to Maine, I think, is that the campaign consultant stole money from her account and has held information, and so the reports can't be filed. So I'm going to work with the attorney, hopefully get more information on who the campaign consultant was, subpoena that person to appear before the commission and or produce the records that are conveniently missing, and hopefully move this matter forward for resolution.
Do we want to set that for hearing a specific date?
I would, and I'd either say December or January, obviously on a specific January date yet, I'll be producing, but I'd say just set it for hearing, I'll figure out.
Do we need a motion to set?
Yes.
All right, we have a motion to go ahead and set it for hearing. Do we have a second?
Second.
For the discussion, all in favor, signify by saying aye.
Aye.
Opposed, same sign, motion carries. Under the good cause category, case 2021S-007, 2021S-023, recommendation of the executive director is find a violation, but for good cause, not impose a fine or impose or refer the matter to the prosecution. Any questions of Mr. Richter? If not, I'll entertain a motion.
So moved.
You have a second?
Second.
All right, we have motion been duly seconded for the discussion. All in favor, signify by saying aye. Opposed, same sign, motion carries. In the $50 category, case number 2021S-016, 2021S-020, and 2021S-047. Recommendation of the executive director to find the violation and to impose a fine of $50. Questions, Mr. Ritter?
So moved.
We have a second.
Second.
Further discussion on the motion to impose a fine of $50. All in favor, signify by saying aye. Opposed, same sign, motion carries. Next category, $25 a day with reconsideration option for case number 2021S-001, 2021S-008, 2021S-011, 2021S-017, 2021S-019, 2021S-022, 2021S-026, 2021S-038, 2021S-048, 2021S-050, 2021S-052, 2021S-053. Mr. Richter, comments?
These are all matters where we have got service on some party, whether it's candidate, treasurer, et cetera. In these cases, the reports have not yet been filed. And so my recommendation is to find a violation, impose the per diem fine, but give them the opportunity to have the matter reconsidered should they file the reports and come back to the commission.
Questions of Mr. Richter? If not, I'll entertain a motion.
So moved.
We have a second.
Second.
The motion's been duly seconded. We find a violation and impose a fine of $25 a day with reconsideration option. All in favor of the motion, signify by saying aye. Opposed, same sign. Motion carries. Next case. is case 2021 S-030. Executive Director recommends consolidating with case number 2019 S-060. Is that correct, Bill? 2019 S-060. Find a
Oh,
violation.
yes, I'm sorry. Yeah, 2019, yes.
And impose a fine of $25 a day with reconsideration option, Mr. Director.
This is a case where there was a prior matter that was pending before the commission. We have now service on the party, and so my recommendation is to consolidate those cases, find a violation, impose a per diem fine, but then give them the ability to have the matter reconsidered should they file the case.
Thank you, sir. Questions of Mr. Director? I'll entertain a motion. So moved. Do we have a second?
Second.
All right, we have a motion been duly seconded that will consolidate the case for 2019 by a violation and post fine $25 a day with reconsideration option. All in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Next group is to find a violation and impose a fine of $25 a day with reconsideration option with payment of $250. Case number 2021 S-003, 2021 S-006, 2021 S-009, 2021 S-013, 2021 S-018, 2021 S-021, and 2021 S-056. Mr. Ricker?
These cases involve circumstances where there was a prior case before the commission in which we violation and imposed a per diem fine. Now they're back a second time, and so my recommendation is find a violation, impose that $25 per day fine, give them the ability to have the matter reconsidered, but I need them to pay $250 in order to do so.
Thank you. Questions of Mr. Ricker? If not, I'll entertain a motion.
Someone,
Second.
All right, the motion's been duly seconded. Follow the recommendation of the executive director. All in favor, signify by saying aye.
Aye.
Opposed, same sign. Carries. Next category of cases to find a violation and impose a fine of $25 a day with reconsideration option with payment of $750. Case number 2021 S-015. Mr. Richter.
The prior matter in this case, 2019 S-021, the commission found a violation and imposed a fine of $300, which was paid by the respondent. But now here he is, oops, I'm sorry, referencing the wrong case. Oh, stuff in the other one back. Hold on there. Hold on. Okay, here we go. Case 2018 S-035, the commission found a violation, imposed a $350 fine in November of 2018. That fine has not yet been paid. And so now the person is back again. This time, though, the report has not yet been filed there. I checked for Secretary's website yesterday. And so my recommendation to find a violation was a per diem fine, give them the opportunity to have the matter reconsidered. But then the $750 fine is obviously much more substantial than the $250 because of the prior fine amount.
Thank you, Mr. Any questions, Mr. Richter? If not, I'm going to take a motion. We have a second.
Second.
The motion has been duly seconded, and we'll go ahead. Follow the recommendation of the executive director. All in favor of the motion, signify by saying aye. Aye. Opposed, same sign. Motion carries. Next category of cases, 5,900 fine, a violation, and impose a fine of $5,900 plus $25 a day with reconsideration option. Cases of 2021 S-031, 2021 S-041.
These cases involve essentially a third time when these groups are back before the commission. That $5,900 represents the amount that would be outstanding from the date the report was due for annual reports this year, January 29th, 2021, up to and including today's date. And so that's where that $5,900 comes from. But then also along with finding a violation to impose a fine of $25 per day on into the future until the reports are filed, and then the ability to have the matter reconsidered.
Questions of Mr. Richter?
I just have one question, because I'm looking at the next category, and the same as that, and maybe I should be looking at that one, like, well,
I think just leave that go until the next one.
Okay.
Typo.
All right, do we have a motion?
so look,
Do we have a second?
Second.
All right, motion to duly seconded Follow the recommendation of the executive director. All in favor of the motion, signify by saying aye.
Aye.
Opposed, same sign. Motion carries. Case number 2021-S-042, United Conservatives of Ohio et al. I have to recuse myself on this single case because of the conflict between my law.
This matter, 2021-S-042, similar to the last case, but I don't know why this matter has been separated. The $5,900 represents the amount that would be standing from the January 29 due date for the filing up till today. But then proposing a fine of $25 on into the future. So that's my recommendation.
So moved.
Thank you.
Second.
If it moves second, all those in favor, vote for it, please take for sign.
Aye.
For raising your hand.
Pass the record to reflect. I will choose.
Yes, I have noted in my notes.
Thank you. Next case, category to find a violation, impose a fine of $23,600 plus $100 a day with reconsideration option. Case number 2021-S-036. Mr. Victor.
We have gotten service on the candidate treasurer, et cetera, who's in here. That $236 for 236 days from the date the report would be on January 29th until today. At $100 per day, they continue $100 on into the future. And so that's my recommendation.
Do we have a motion?
So moved.
Do we have a second?
Second.
We have a motion been duly seconded that would recommend follow the recommendation of the executive director. All in favor, signify by saying aye.
Aye.
Opposed, same sign. There's following cases have been continued for service. 2021-S-002, 2021-S-004, 2021-S-005, 2021-S-010, 2021-S-012, 2021-S-014, 2021-S-024, 2021-S-027, 2021-S-028, 2021-S-029, 2021-S-032, 2021-S-033, 2021-S-034, 2021-S-035, 2021-S-037, 2021-S-039, 2021-S-043, 2021-S-044, 2021-S-045, 2021-S-046, 2021-S-049, 2021-S-051, and 2021-S-054. Those cases are continued for service. Chair. That takes us to the next item on the agenda, which is the executive session. Before we go down that road, this has been a longer hearing than I think many people anticipate. Are we still prepared to go forward? I'm looking,
I was gonna say-
I'm not looking at you. I'm looking at Mr. Grower and I'm looking at Tasha.
I have 1:30 command performance done in Franklin County Court Common Please, so I'm gonna duck out about 10 minutes.
Okay. We can still go ahead and do it?
Hold on.
I was gonna say, that's a time.
You have a steel conflict too, Kim?
2:30.
2:30. What time is it?
It's 1:52.
About 1 o'clock.
It's 1 o'clock instead.
Or 12:52. I'm sorry.
Well,
10-7 is never getting.
well, we're gonna, I envision, without going into details, when we're on executive session, having Phil kind of fill us in on what he's done and then having us ask questions and then having a discussion about what, if any, compensation. And then coming back into the public session and see whether or not there's any action to be taken on our executive session that can be taken out probably. That's just one fair. So, I mean, this is one of the things I don't want to delay, but I don't want to rush either. I think it's really important. So what's?
So are you saying, are you saying on the 7th, come in an hour early? Take care of that. Is that what you're suggesting?
I would move it someday other than some.
The 7th is gonna be long.
I know it is.
Yeah, no, I'm okay with that. I mean, I'm fine with that if everybody else is. I'm not making a trip down to Akron and Lima.
So what's our next date after that? Let's go to second.
The 28th.
How's that look?
Not too bad, I don't believe. How's that for you, sir? But I don't, unless something gets continued in.
I believe there are 3 complaints, I want to say on, and then 64 referrals.
Yeah.
So nothing.
Nothing on the order.
Yes.
I'm on call later. See Jeff.
And I'm not gonna be.
It's not a big deal for me.
And we can always do right now.
Is that fine then?
Yeah, I have no problem.
I think that makes more sense. I don't want this to be rushed. I think it's a really important process.
Absolutely.
And we haven't been able to do it because of the pandemic, so.
Right.
All right, so with that, and then we'll go ahead and continue the review of the executive director until the second meeting in October. Okay, you're all right with that? Yeah.
Okay. And before we adjourn, someone mentioned next month's meeting. I have a commitment at 6 p.m. I'm wondering how viable that might be. That means I'd have to leave like 3:45.
Yeah.
I'm not sure that meeting's going to be over by then. What's the thought?
I don't think, 3:45.
But you don't have to, I mean, you can continue the hearing to a subsequent date. You're just gonna have to get it in before the end of the year.
Correct.
I mean, you want the same Pam.
Right.
That's all I'm saying. So
Are you talking about Hicks versus Freeman?
Yeah, I'm talking about if it's not done in a day, if I agree,
And
there's always the issue too of, attention spans and ability to continue to serve information after so long, it gets hard for people, so
I felt that.
exactly, I'm talking about it, it's only one night.
In
I was
addition
watching the
to,
next morning, so I mean, it can go on.
in addition to, we have a lot of other cases.
there is one other substantial case that again, Mr. Price gets recused from on a preliminary review.
On the 28th,
On the 7th. On the 7th. So,
That is where's the long day.
but preliminary review that, I mean, we'll have argument, but it should go. Something different.
Well,
The case against the American Legislative Executive, Alec,
Alex,
And
American.
3 members of the Republican General Assembly. That's the case. Don't have some response yet from Alec, from the representatives. I have not had the opportunity to look at it. I will be getting that out to me hopefully tomorrow. Anyway.
well, sorry to interject, but
No,
one
that's
other
okay.
thing is we could, schedule it, depending on how it goes, we could add a meeting. And it's really in October, maybe 3 or somewhere, or early November, whatever, to just get Hicks disposed. Doesn't have to be on a regular scheduled meeting, but if we're thinking about doing that, maybe having people, polling people, commissioners, see what their availability is. I'm not seeing that, inviting extra meetings, but sometimes.
Well, I mean, that makes sense. I got a blackout date in, October, but it doesn't make sense.
Okay, well, I'll reach out after we get done here, either sometime today or tomorrow, I'll reach out and ask everybody to let me know if you're not available on particular dates, only in the future after the 7th. We certainly don't have to discuss that with
Great.
Mr. Hicks or Mr. O'Brien as we go into this, but we'll be prepared to, we'll be prepared in case we need to do that.
And it doesn't necessarily have to be on Thursday, but it just, as long as we public notice it, and if that's the only thing on the agenda, if we can have 2 or 3 days available, so that if we're not done by 3, which people expect, we can at least provide alternative days and.
I just know looking at my calendar, it's horrible between now and the end of the year, between depositions and trial dates. I mean, I figured out the elections commission dates, but other than that, getting the additional dates, I'm scheduling now in December.
Okay.
So it's not gonna be, for me, it's not gonna be easy to get an additional date.
Here, let me know, what it is and we'll be prepared.
So as far as my question, how viable is that? On the second,
Good point, yeah.
we're going to get out of here by 3:30.
Well, we control our schedule, so we can be out of there by
Right.
3:30.
And we can go into, we've done it before too, where, and not necessarily point to you or anybody else, just say, okay, we're here until 3 o'clock.
Right.
And at that point, we're cutting it off. And if we're done by then, we're done. If not, we'll continue it. And Mr. Bryan is probably the good and bad under that kind of circumstance. I can't speak to Mr. Hicks, who's never been through it. And I'm not gonna sit there and, try to favor one over the other, but we've done that before where, especially like we have false statement cases. Where, okay, guys, a commission member has a conflict that's gonna keep them away here. We can get this done today, and we can do it this time period, or continue it. It's up to you guys. When we get close, we'll ask you to either say you're done or not. And so I guess that would be the recommended approach that I would take.
What I have, I could always cancel. I would sooner go long and get this done than,
What you say about going along and getting it done, though.
I can fill it in.
But Bill talks about that, so back when the false statements many years ago, our problem was now, so it'd be years off.
I remember.
Yeah. 11 o'clock at night, you would start at 7 in the morning.
Oh, that'd be a long.
I mean, it was. It was.
You don't want your per diem?
Right.
Stay focused.
We had our time.
I'm gonna excuse myself.
Okay.
Okay.
Bye.
Hey, can I follow up with something Scott said though, too, and this conversation? We need to start getting the dates for the hearings for next year. Because I know, like, we've had this conversation. In my case, a lot of federal cases have been held because of the pandemic. Now the date is set in for the next 6 months to a year. So, other people are not lawyers, are probably having any kind of problems too. So don't get those things locked in.
Don't disagree, and, there is nothing sacrosanct about Thursday commission meetings. We more or less fell into Thursday commission meetings in 1990, probably late 1996, when, just kind of we started scheduling and doing things, and then talking with commission members. That became a good day, because I think the first we had been on a Tuesday, not that that matters. But it worked out for everybody then, the Thursday, and at one point we started around 9 o'clock on a regular basis, and then one of the members had travel from out of town and said, 9 o'clock's a little tough, we do 10. And so we've really fallen into Thursdays at 10. So if you guys want to suggest a different day or a different time, it's doable.
Need a better date?
It's doable.
No, I have the most flexibility than anybody.
That's what everybody else,
I mean,
the Thursday was a good day.
You find another day other than.
Yeah, other than Thursday,
For next year.
for next year.
Well, how does that
I think
play?
I'd probably.
Aren't we at the mercy of the legislature as far as replacing 3 of us?
Well, that's another topic we need to have a conversation about, because we can't if we're start hearings between now and the end of the year, and 3 of you folks roll off at the first of the year within 60 days after that, then these people are gonna have to go back and watch videos or read transcripts to get up to speed, or we're gonna have to go ahead and produce all the evidence again. So, I mean, there's a lot of things we're thinking about between now and the end of the year.
But what's the, just to refresh my memory, what's the total rule?
60 days,
Just
50 days, unless there are,
But if they're appointed in that window, they're gonna hold over.
right, they hold on for 60 days unless they've been replaced. Okay, so Catherine and Dennis, the 2 party members, more or less, they could, the governor's office could announce a replacement hearing, let's say on December 15th, that person would then start on January 1.
Right.
Or at some point in that period, could, announce an appointment. They hold over until their successor is appointed. Now, this.
But no more
group here-
than 60 days.
But no more than 60 days. March 1 is the last day.
Yeah, party membership doesn't mean anything. I was appointed 8 months late.
Yeah, me too.
Oh, yeah.
Yeah, I was like 8 months.
Yeah. Now,
They
we
couldn't hold
control,
hearings. We couldn't even hold hearings for
Right.
months.
you guys control Scott's replacement. And so that's one that could be made at any time. We can, his term actually ends on December 31st, so we can't appoint somebody now and get rid of him, even though we would like to.
So we can't.
Only a best.
A meeting early. That's the moral of that story.
Let the record reflect our cause. I will, the next time I see Mr. Norman, I will probably reflect the moral defensive of it. So his term, goes through December 31, and we could appoint somebody to commence on January 1, or at some point, then their holdover period, January, February, and then make a subsequent.
But as we talk, that we have to have independent candidates that we go ahead and interview ourselves and make a recommendation.
That is
Our recommendation we select.
correct, correct. That is selected by these 6 people
Yeah, and his,
right here.
at least my prior history, which was years ago, some of the commission members also suggested, independent, that you use somebody or, communicating with people who could recommend somebody to you, because it's not it's harder than you think to find independent people who are interested in this and willing to participate. I reminded Phil that there was somebody the last time he interviewed, which Dennis might have been here, that I think when Scott was selected, that a lot of people liked him. I can't remember what, so he said he'd actually go back and look, and I think the one before that was one that we were having a hard time, and some members, of the commission sort of proactively came up with some names of maybe a half a dozen people that we brought in. So if people have anybody in mind or something in your community, because I think, statewide representation is important too, and we want to be for it. And diverse representation on the commission. I mean, that was really, we had some numbers back when we were looking, back in that day when we were looking at, we're really interested in making sure that we're maintaining the.
Yeah, we don't have to have 4, we don't have to have 4 lawyers or 3 lawyers.
Right, you want that many
Oh,
lawyers,
that's diverse.
kick them all off.
No, I think it's really important to have a cross-section.
Yeah.
Kind of positions.
But I do, personally, I really value what you all say, because I feel like that I'm not learning, if, you know what I mean, if I could go through and look everything up, but how do you know what to look up before it comes, before.
Right, and I will say there was some sentiment to that, there has been some sentiment to that for the independence, and my recollection is, so Warren wasn't, but independence, I think, Harvey was a lawyer. Yeah. Larry.
Everybody else said that Warren has not, Lee Grimshaw, Harvey, and Mark Webster.
Yeah, we're all lawyers.
We're all.
Does the commission post for the independent in any?
We have not officially posted anywhere, no. At this point, and I have not yet done it, I was planning on reaching out to the governor's office to say, hey, if you've got any suggestions. I have reached out to Don Bride, Don McTighe, and Mark Weaver, who are persons who regularly work. And Mark Weaver has been very productive in producing independence. Mr. Grimshaw, who was the prior independent for Scott, was one that Mark came up with. I contemplated reaching back out to him to see if he'd be interested in serving him. I have not done so. Mark and I are supposed to have lunch in early November. He's out of town. He was, if you identify something like that to him, he'll come up with it. And he's had other suggestions as well that have been good.
Yeah.
And so it's kind of what we said, but.
Got a lot of things on the plate between now and then.
Yeah, but I encourage people to also think and reach out, if about the diversity, so.
I think that independent thing might be very critical, because we don't want it to be too tight, but that would keep us at quorum.
Correct. And that was one of the problems that we had the last time. We didn't get it.
Keep it going.
Right.
We couldn't get it done.
Sorry.
Yeah.
That's why I have
Keep it
been,
going.
I have been looking.
Yeah, it was 8 months for me.
Yeah, I started
Right.
thinking.
For Scott, it was
That was
9 or 10 months.
right. Well, that was the issue. We did not do it in a window of 60 days. So when Lynn went off and the governor's office hadn't made appointments, then all of a sudden we only had 4 members. And obviously 4, when you need a quorum of 5 to meet, 4 couldn't meet. And so I would certainly encourage action, probably no later than January.
Well, and I would also say that at least historically, the commission interviews independent candidates, so you've got to have a window of time that you can get people in and talk to them.
Right.
To appoint them, so it's not just about a get a name. Early.
That's a day that we should probably schedule as soon as possible, so we can get on our interviews.
Yeah.
Yeah, maybe we could select that first before the end of the year, just then effective January 1st, so, right? Correct. Yes. Smart.
Yes. Or did he come in that 60 days?
Well, just looking at the fact that, like, the governor's office, I'm not all governor's office.
Yeah, we're operating.
Historically, it's slow in making those appointments. And we have some critical cases
Yeah.
that, or so I'm gonna have to recuse because of my law firm had a conflict. We can find ourselves in a position where we only have two people, maybe three people.
Right.
So, agreed.
Yeah, and Terry, you still have the January and February window.
Right.
December would be great. But you've got a window, but by the end of February, you've done, preferably before that.
But if those cases would start out, some of the cases we're seeing now where they would take place over 3, 4, 5, 6 months or longer.
Yeah.
Could be an issue too.
And it's always an issue if you have to continue. If a hearing starts, you have to go to a second day, and have somebody that heard part of it.
And the firm better served by starting sooner too, given that, next year is, again, election year.
Sure.
Election year, 22, and a lot of our, filings and stuff seem to be more primary oriented. Well, sometimes it's true.
Yeah, anymore, that.
Ask
You
somebody
got them.
up to speed,
Yeah.
you know.
Well, that's why Phil and I had this conversation this spring and he reached out in the summer to the General Assembly, to at least put them on notice.
And I will follow up on that too, with just a brief, I sent letters to ownership on both parties. Just kind of saying, hey, everybody, we got this come up. And I said, I got calls back from, I can't remember whether it was, a staffer with the House Republicans or Senate Republicans, just kind of inquiring generally about it. But I'll send out a follow-up notice, just pointing back to my previous letter and say, hey.
So it is, what's the Elections Commission?
Yeah, nobody has said
We have
that.
to make appointments to them?
Nobody has said that.
No.
Good. One other thing that I want to apprise everybody of, I told the chairman about this yesterday when he and I were chatting briefly. Everybody remember our wonderful Libertarian Party case? That was challenging, the appointment process.
There was, yes.
Okay, that was decided in favor.
What was the plaintiff's name?
Oh, well, it was,
Capital law professor was.
Mark Brown, who was the Capital Law professor doing it. Anyway, they've filed a writ of certiorari with the United States Supreme Court. on it.
Fine.
Yeah. And so
Only along with others.
You won't be very well.
That's a response. Good one. AG's office. So the AG's office is representing us. I will send out to you guys over the next couple of days, the writ and the response that the AG's office has sent. I didn't have a chance to do this. But now it's back in their ballpark. The AG's office was saying that they have a rebuttal time, like 2 weeks or something like that. But it took a little longer because I was rather surprised, but what they were saying is that because of the pandemic and everything, the U.S. Supreme Court extended the time frame for filing certiorari writs to 150 days. And so they used the extra time and they did that. So it doesn't necessarily affect it doesn't really affect any of you guys. It would affect the independent presumably, based on the way I feel pretty good that this Court will reject certiorari. I could be wrong, but the real impact on a decision like that would be as it relates to all the various other boards of elections and the ramifications that they come with that. When it comes right down to it, in the grand scheme of things, if they declared our process unconstitutional, then you got to do it differently. We expanded it to allow for minor parties, which is kind of what they're looking. From our perspective, so what? In the grand scheme of things, because it's not a challenge of you guys.
So the petition for the certiorari has been filed in the
And we filed
I don't know why that's even.
I don't know whether it's, I'm sorry.
I don't know why it's called the garage.
Because it's there's a lot.
Yeah, I think you can pause it.
Okay, all right, one last thing, and then we're gonna have a motion to adjourn. Phil, there's a number of items that we talked about in terms of general assembly request. Now, can you just send us an email on that?
I will send you the email that I sent.
It's just up there. All right, there's no further business to come before the Ohio Elections Commission. I'll entertain a motion that we adjourn. Do we have a second?
Second.
Never have any problems getting a motion.
No, somehow that always-
Also, signify by saying aye.
On October the 7th, we won't have a problem.
Thank you all for being here. Back in.
See you guys next month.
See you next time.
I wasn't sure.
I have a class meeting, so.
He really shut down.
Oh, absolutely, absolutely. Yeah.
Well, we all want to do it.
Yeah.
Yes, I'm sorry, I didn't see your email.
Well, it's been a long.
I was like, oh my gosh, yes, and then this, oh. Yeah.
Okay. Christmas with these here, we gotta collect them on.
Yeah.
Yeah, no, thanks, Bob.
Guys, appreciate everybody.
You're welcome.
Yeah.
No, I never actually walked about it. I would make sure, notify the comment to the point.
I know.
People just, recycle. Bad with my email. Bad with my email, like, I was like, you could email it out.
Well, when I said. Don't ask me about it, I go, well, I'm not going to email.
Safe travels.
Thank you.
Chris, I did get mine back.
I'm like, what?
For travel? Awesome.